May I please, Lordship? My lord, this matter was listed yesterday.
Yes.
The cooperative society appeal matter.
Yes.
Elected persons were not given the charge.
Matter was called out twice, sir. You were not
I'm
here.
sorry for that. I was on
Yes.
leg in court number 2, my lord.
Yes.
So Lordship,
So
may
that is
kindly-
your prerogative. Where
Hello?
to argue?
My lord?
That is your prerogative. Where to appear?
No, even then, my lord, there was a ref case I was arguing. So my lord, this matter may kindly be listed tomorrow.
Sorry. No.
Then
Next.
at that as your lordship convenience.
Mr. Counsel, we passed it over once on your request. It was called out second time. If you are not having that courtesy to appear in court number 1 on the ground that you are busy in another court, then that is your choice. Then the dates will not be given as per your convenience. We are firm on that. Thank you. You can call out the case. Yes. Yes. Yes.
Item number 19, my lord.
Yes.
May I pray for adjournment, my lord? Yesterday I have given the adjournment slip, my lord.
Okay, counsel with the plaintiff has circulated an adjournment slip. The other side
Other side, I have taken the consent.
has no objection. List after 4 weeks.
And item 42 also, my lord.
42 also same.
In the adjournment memo, my lord, consent, no objection is there, my lord.
Okay, 4 weeks.
Highly obliged.
Yes.
May I please, I beg to mention item number 16, my lord.
16.
16, 16, my lord.
Yes.
Appellant instructed me to withdraw this petition, my lord.
Withdraw.
Withdraw, my lord.
And counsel for the appellant raise liberty to withdraw the writ appeal. Hence, the other side has no objection. Hence, the instant writ appeal is disposed of as withdrawn.
Obliged.
Pending applications, if any, are also disposed of.
Obliged.
Yes.
May pleases you, lordship. Pertaining to item part 2 matter, your lordship, item number 25, your lordship.
Yes.
I am appearing for appellant on behalf of SC Kyal, your lordship.
Yes.
I have taken consent of the other side. Kindly matter may list after 2 weeks.
25.
25,
Part 2.
part 2,
Part 2 hearing.
hearing list.
Why not?
Oh, okay. We'll not be taking up now. Okay. Yes.
Deeply obliged.
My pleasure, Lord.
Yes.
My Lord, I'm praying for a listing appeal tomorrow, my lord. It was filed on 23/2/2023. There were some defects we have cured it, my lord.
What is the matter about?
It's a matter of the vending rights of the petitioners. With regard to my lord railways,
Okay.
there's a common order also, my lord.
Very well. Get it listed tomorrow.
My-
Yeah.
First, I'm praying for listing of an interlocutory application filed in a pending writ petition.
What is the application about?
Lordship, the application is seeking a stay. Lordship, what has happened is, the respondents in the transport
List
department,
it on Thursday.
Thursday, Lordship,
Yeah.
obliged, Lordship.
Yes.
Item numbers 1 to 6 of daily list for orders.
Matters are coming up in the orders category for orders.
May I make a submission here?
Yes,
In
please.
this series of appeals, I'm not going to appeal. In WA 222,
Yes.
here, my lord, the service is complete. Notice was earlier issued. Lordship has noted it in the IA 92926 of 2022.
Yes.
And since it was a substitute service, paper publication was made, those were placed on record.
Okay.
And the appeal is also notice is issued, and all concerned parties are there before your lordship in one form or other.
Yes.
They are all here. So in that view of the matter, I think service is complete in all the matters
Yeah, it is complete, then Lordship may be pleased to fix the matter for
for hearing.
disposal.
All right. This court is informed that parties have been served in all the connected appeals. And pleadings are also complete. Thus, on the prayer of learned counsel representing the parties, lists this bunch of appeals for hearing
In the second or third week of May, Lordship,
3rd week of May.
3rd week of May.
It's okay?
My lord, can it not be preponderant? It will be
Well,
preponderant.
several other cases were fixed already.
Let that, my lord, let
We
that.
already fixed
Lot of cases were fixed.
fair large number of cases in the meantime.
Here also it should get little priority because so many people are involved here and they have.
Why not hear it
Today,
today? It will sit argued today.
today, my lord.
We'll tell you of an incident which took place in Rajasthan High Court. There was a very tough division bench. So I was having a murder appeal and had moved an application for early listing. One of my associates, he was a very young boy, but he was very good at arguing criminal matters. So I anticipated what would be the response of the bench when the matter is called out for passing orders on the application for early hearing. So I told my associate, be prepared with the matter. So the application was called out. The court said, all right, application is allowed, argue.
Yes.
Well, my associate argued for 45 minutes. Ultimately, the bench had to say that we tried our best to dislodge the young man, we could not succeed. So same is the position here. You can argue.
Well, we can start it. We can start it, no doubt about, but then which.
We have got
all
till
everything cannot be
4:15.
there Today.
We have got till 4:15.
Yes.
Time till 4:15. So you can, if you don't conclude, we'll spill over the matters tomorrow.
Then lordship may fix it tomorrow, my lord, we'll agree. Because today,
If it-
all my
if it is-
friends may not be ready. with
If
all
it is,
the-
if it is adjourned
These are not-
tomorrow, if it is adjourned, it doesn't come up tomorrow.
My lord,
This
otherwise-
for hearing in 3rd week of May.
Highly obliged, Lordship.
Item number 7 and 8.
This is part of
My lord, for the timing possible, my senior is coming on the traffic jam, he's coming.
pass over for
For the
the time.
timing possible.
Yes,
The part heard matter, my lord.
Yes, yes,
we know,
I'm ready to do this.
Yes, yes.
He's bring me. Sir. For the timing part. Yeah, I'm fine with that, yeah.
Item numbers 9 to 13.
আমি 12, 13,
9 to কোন আছে কিটা?
9 to HR, 10, 11, Dr. Tharatil.
My lord, in this series, I am appearing for item number 12 and 13.
Yes.
কোনোবা আছে নে? Made people also.
So you'll be leading the arguments.
My lord, actually, I am appearing in 12, 13.
But what about 9, 10, 11?
Yes.
We can't hear them in
I think
peaceful.
9, my learned friend appears.
11 and 12, they.
My lord, in one case, I'm told, my lord, the petitioner has expired. My lord.
কোনটো কোনটো case?
Proprietor probably or the partner.
The proprietor has, it was a proprietor from. Shwekiyat trade.
আচ্ছা আচ্ছা আচ্ছা।
Shwekiyat trade.
So here we exit in the utility and probably, but actually member to not.
Please ensure
Item 11,
11.
the sole proprietor died, I'm told, by his counsel.
Ms. Chaudhary,
My lord,
then the whatever implement application bringing on records the LRs if required,
that will be required.
that process is to be
So if you have.
completed.
In that case, my lord.
Let's first decide appearances in all appeals.
Okay.
Number 9, you are appearing.
No, my lord. Oh, he's, yes, yes.
9, number 10,
Then.
Mr. N. Datta.
And the toy is also
There is
no
no
longer
more.
there.
Then the other councils,
Other councils inform the court that they are.
No. then we'll have to issue.
Other council on an earlier occasion appeared, then they said they no longer represent them.
So then we have to issue notice to the
Notice,
party
That's the whole difficulty.
and item number 13, 12 and
12 and
13,
13,
you are representing.
Yes, yes.
And item number. Yes, these are the series. So 9 to 13,
10 and 11, the council, 11 was there.
10 and 11 notices will have to go.
Yes, it looks like.
Okay, 10 and 11. No one appears for the writ appellants. Let the writ appellants be notified through registered deity post as well as email for making suitable arrangement to prosecute these appeals in this court. Rule is made returnable on 10th May. 9th May.
Nine.
Can you give us 11th, number 11, please?
Yeah, Monopoly is, na?
The legend.
I think according to my learned friend, my lord, the person died. So
That's not. In council. In council, Mr. Submits that he has been informed that proprietor of the appellant firm
So Pranjit Swikia.
has passed away. Shri Paranjit Sekia has passed away. Who will be informed then?
it will happen. It will happen.
Proprietorship firm, the things will end then.
Hmm.
It's a proprietorship firm, the matter comes to an end then.
Looks like
These are matters of tender.
tender, my lord.
So what is surviving?
My lord, surviving, my lord, because they will, otherwise they will forfeit our security, my lord. Otherwise, this it is not going to harm anybody's interest because.
Then if, all right, we'll issue notice, we'll get the response.
Yes, yes.
Then we'll pass the
Then also we'll
appropriate
take the matter.
Yeah. Deep level. List on 9th May. Okay. Both. You don't know, that's not a
10-11.
10-11.
All the matter. The respondent counsel for all matter.
Yes.
Nine.
No, but statement we never got right up. We'll get the response to notice. दो का ही notice
Instead
करते
of
हैं, दो का ही notice करते हैं. Other matters you mark the appearances for the both the parties.
notices only on 10 only.
10-11.
Item number 14,
14, counsel for the appellant has circulated an adjournment slip list after 4 weeks. Do you have any objection?
I'm responding.
Do you have any objection to the prayer for
No,
adjournment?
he's sick, I know.
Okay. 4 weeks. Right.
item number 15,
Excise appeal, Mr. KL.
My lord, with all humility, my lord, the arguing counsel was to come from Kolkata, my lord. Because of certain personal inconvenience, he informed me that he is not in a position.
Mr. KL is there.
My lord,
You are for the respondent.
I am the appellant, my lord. I have
Mr.
informed-
KL represents.
Yes, I have informed Mr. Kayal, my lord. So
So
lord,
you are for the appellant is the
Appellant.
excise, central excise.
I am for the appellant, my lord. Sorry, my lord, I am for the respondent, Mr. Kyle is, sorry. Mr. Kyle is for the appellant. Yes, the
Appellant.
word is okay. I have informed him, my lord.
Then counsel, Mr. So-and-so submits that the respondent would be represented. The arguing counsel
Yes, my lord.
is not available today. And thus, the matter may be adjourned for the time,
My lord,
for the present. list.
My lord, my lord, convenient date so that he can come, my lord. April
List.
2021 or 27, lordship,
13 June.
13 June. I'm deeply oppressed.
item number 17,
Adjournment slip 4 weeks.
May it please your lordship, I'm appearing on behalf of senior advocate, Mr. H.K. Deka. He's not well, your lordship. The matter may be listed after vacation, your lordship.
Which one?
Item number 17, your lordship.
17, all right, 4 weeks.
Much appreciated.
item number 18,
Yes.
May I please your lordship, with the consent of the other side, my lord, may I take a slide accommodation, my lord? Let it be listed after vacation, my lord.
So you are taking the court for granted. No adjournment request in advance. Why are we listing hearing matters then?
In fact, my lord, I'm appearing for BTC, my lord.
Yes, so you are welcome.
My file is misplaced, my lord.
Now a new argument. New excuse. And counsel, Mr. So-and-so, appearing for the BTC, submits that his record has been misplaced and he needs time to to reconstruct the file. List after 6 weeks.
Matter number 20.
My lord, after some time, my lord.
Is it in direction or what?
No, my lord, I request, but I'm waiting for 2, 3 documents, my lord, just for after 5, 10 minutes, my lord.
10 minutes?
Yes.
Okay.
Matter number 21.
Who will file the documents?
Lordship,
Yes,
Lordship, in this matter, our additional AG is appearing, Lordship, he's on next in other court, Lordship. So I need some accommodation, Lordship.
okay. Also for the timing?
Lordship.
Yes, okay. Also timing.
Matter number 22.
Lordship, can you pass over for timing, Lordship?
The bar feels we can rise. No one is prepared to argue the matters. Pass over. All right.
Matter number 23.
Yes,
May I please, Lordship? Lordship, matter pertains to custodial death, Lordship.
okay,
Custodial death of the son of the petitioner.
yes.
In this matter, Lordship, son of the petitioner was arrested by police, Lordship.
Arrested by police.
Lordship,
Okay,
on 22/12/2018,
yes,
and he was produced before the learned magistrate. In the meantime, Lordship, forest authorities, that is respondent number 6, filed an application for custody, Lordship. Accordingly, custody was given to him, Lordship, on 5/1/2019, Lordship. And
Yes.
son of the petitioner was found dead on 8/1/2019 in the office of the respondent number 6, Lordship.
respond number 6.
Respondent number 6, Lordship.
Who is the respond number 6? Range
Range
Forest Officer.
Officer, crime investigation range.
Okay. Yes. Then what proceedings followed?
Lordship, in this matter, rule was issued on 17/5/2019, Lordship.
After the death, what proceedings followed? Let us know.
There might be.
What is the fate of the FIR?
Lordship, not yet came into logical conclusion of the FIR, Lordship, lost by the petitioner, Lordship. Petitioner lost the FIR, Lordship.
2019 FIR.
Lordship.
Rhino horn. Yes,
My lord, this is the matter of 2020, 19, my lord, we don't have updated instructions, my lord. And after we have assigned by this, brought in by the department, this is the first time it has come. Well, I'll humbly pray for a week's time, my lord.
where is the FIR, Mr. Counsel? FIR lost by the petitioner?
I could not annex during that period, Lordship. That was registered, Lordship, under section 302/34 IPC, Lordship.
You only have the serial number, nothing
Serial-
else.
PS case number and sections, Lordship.
Police station?
Police station, Bishwanath Chariali PS case number, Lordship, 4/2019.
Who represents the police in this case?
GA might be, Lordship, government.
Well, I have taken instruction. I'm not the GA, she's the GA. Well, this case, my lord, which he is harping upon, my lord, it is going to FIR, my lord. Finally,
Maybe where is the report?
well, that is the reason I'm seeking adjournment for the week, my lord.
Mr. Counsel, Mr. So-and-so, representing the Department of Home.
I am for the forest department, my lord. Allegation is. on
We
the-
want report from the SP, Shonitpur.
Well,
You are there?
Yeah, okay.
Where is the report of this FIR?
Lordship, the matter is posted after a long interval and inadvertently we are not receiving any instruction.
Presenting respondent number 7 shall keep the latest factual report pertaining to FIR number so and so available for the court's perusal. FIR number 4/19. PS Viswanath Charali available for the court's perusal on the next date. List on 11th April.
Lordship, I have a small pair. Inquiry report may also be called for. Magistrate inquiry report.
The
That's for-
report of inquiry conducted by the concerned magistrate under section 176 CRPC, if any, shall also be summoned and kept available for the court's perusal.
And postmortem, Lordship. Postmortem, Lordship.
That would include everything. Yes.
All right. Item number 24.
Yes.
Milord, to be fair to my clients, Milord, I could not prepare it last night due to some personal inconvenience. I folded and prayed before Lordship, Milord. Can it be taken up immediately in the next week or after the beautification as per your Lordship convenience?
My lord,
It needs some amount of hearing, Milord.
my lord, this writ petition is against an order of CAT where the petitioner case for promotion was not allowed. Now, my lord, the reason was he was implicated in the criminal case, a charge, FIR was lodged. Now, my lord, during the pendency of these cases, he has been convicted and a punishment of compulsory retirement has been imposed. So in view of the changed circumstances, my lord.
Sir, then,
I have a case, Milord. I will apprise your.
but if he has been compulsorily retired,
Retired.
what is the,
But under the date, the important date was 21 March 2017. On that date, when his case for promotion was considered and his juniors were promoted, there was no criminal case.
we understand, but what would be the consequence now? Once he has been,
Consequence, I'm explaining, Lord. Consequence is he got the national promotion also. He is compulsorily retired. And his appeal against that conviction is pending before this honorable court. And he is yet to retire, superannuation, arrive at the superannuation for around he is retiring on 32.
whether the order of compulsory retirement has been challenged,
No, my lord.
That I do not know, my lord.
this is a statement coming from the other side.
Maybe. Milord,
That is the statement I've made in the affidavit. To our knowledge, it has not been challenged. And that order of compulsory retirement, your lordship will find in my affidavit in opposition. Page number, my lord, it starts from page number 11 and the operative part, your lordship will find at page number 12.
Yes.
Last paragraph, considering the grave and incriminating charges and on careful consideration of the.
PC Act.
My lord, and annexure.
We don't
at page
understand.
10.
If he has been convicted for the offense under PC Act,
Yes.
he had to be terminated. That is a normal, the natural consequence. Why compulsory retirement?
It was not.
Leniency.
There are some, I cannot disclose everything, Milord. But the thing is this, if his conviction goes. And an
Maybe, for the present it is there. So the natural consequence,
My lord,
n number of Supreme Court judgments.
My lord, Anil Sarkar, that judgment lordship is aware, my lord. That day also your lordship was referring to that
Yes,
judgment. That Anil Sarkar case, my lord, it was crystal clearly said by the Honorable Supreme Court that on the day of considering for promotion, if there is any criminal cases pending against him, then my lord, silkover procedure will be prescribed. Otherwise not, my lord. Otherwise not. If, my lord, what will be the consequences? I am just want to know from my client. If tomorrow,
Counsel,
if the High Court
we
reverse the conviction,
frame a question here that
Compulsorily retired now.
we
I'm
might,
getting promotion, my lord.
we
Sorry,
might,
I'm getting pension, sorry, I'm getting pension.
we might frame a question that in case where a delinquent employee is convicted for the offense under PC Act, the natural consequence should be termination. We would frame that question and they would be called upon to answer. You just have a look at the law.
But the department has chosen not to terminate.
But you are not
We will inspire
I'm not
them.
challenging termination, I can choose, this is my.
We will inspire them to do so, even now.
Well, at that point, I have no instruction to say anything on this, my lord.
Very well.
But the law is clear to my
Also, the
understanding.
appellant submit that is, petitioner submits that he is not prepared with the matter. Counsel for the respondent submits that during pendency of this writ petition, the appellant petitioner has been convicted for the offense punishable under Prevention of Corruption Act and consequent thereto, the penalty of, he has been awarded compulsory retirement. He has been compulsorily retired from service. As per respondent's counsel, the order of compulsory retirement has not been challenged any further. List after 4 weeks as prayed. Let's complete the list. We'll follow them. Yes.
Item number 25 and 26.
Meet with your lordship. May I implore your lordship to take up item number 26 first, my lord, identical matters. Only, my lord, I have prepared note in this.
26 first.
My lord, the response of the petitioners is that, my lord, in the revision of pay rules 2017, the date of
Respondents are there? Not there.
my lord,
Who's for the respondent?
or the state, my lord.
State is at a loss. Is there anyone for the respondents?
Finance and pension.
I'm sorry, Lord.
You are here?
One of my colleagues is appearing, Lordship. Today he has some problem, Lord. Lordship will take up this matter after 1 week.
Mr. Saikia, do we have to make alternative arrangements for state council? In every second matter, the same argument is coming. You are not aware. Matter has been listed after so many days. So what? It's a hearing list. We have come across 4 matters at least, wherein the state council are totally at loss. Should we create a special category that these matters will definitely be heard, even out of the hearing list?
The only thing is, sometimes we miss it because standing council are not indicated in the cause list. That is one reason. Lordship, on
You
the
need,
next that
need to improve the things a little.
Lordship, I'll look into it.
Please do that. Mr. Chaudhary,
My lord.
they are not prepared totally. They,
Begin AI.
maybe we'll think of replacing you by ChatGPT. That's a possibility. We also face the same risk. Okay, and council, state council, Mr. So-and-so submits that he is not prepared with the matters. List after 3 weeks.
Okay.
Okay. The proof of, after this page, you can call out the parted matters. After this last matter, on this page, you will call out that, yes.
Item number 27.
CAT matter, your lordship.
Yes.
The petition was allowed, the OA was allowed. And they had come for challenge.
Where is Mr. KL today?
The RK Dev Chaudhary did call me up. Possibly he is having some difficulty with locating the brief and all, your lordship.
Okay.
We fix some other date, your lordship, if your lordship is.
None present for the Appellant Union of India. List in 3rd week of May for hearing. Okay. Now we can call out the parted matters. Yes.
Item number 7 and 8 revised.
No, I'm sorry, my lord. The other days, my lord, the respondent number 11, my lord, they took time to get some clarifications. Otherwise, my lord, matter was already heard at length.
Now you will have to refresh the memory.
My lord, the case of the, my lord, the petitioner is that they have challenged by filing the writ petition, my lord, the interim order, which was passed by the tribunal, declaring the respondent Sam as the legally married wife of, my lord, one late Sanjit Malakar. And our whole contention before this honorable court while challenging the interim order, the tribunal doesn't have any jurisdiction to decide the marital status.
Matrimonial
Yes,
status of the
marital
parties.
status. And my lord, on that point of view, I further contended, submitted before this court, they suppress the material facts. Because my lord,
Can you briefly refresh our memory, please?
yes, my lord.
Yes.
Then, my lord, we raised a question, my lord, before the tribunal, that tribunal is lacking jurisdiction to decide the marital status.
Right.
Despite that fact, my lord, ultimately tribunal decided. The
Can
marital-
we read the finding, please?
Yes. Well, I'm reading at page 262.
262. Yes.
And just relevant portion of the imprint finding.
Hmm.
Paragraph 34. For the foregoing discussion, it is highly probable that there was marriage between Purnima Malakar and Sanjit Malakar, though it was maybe during the subsistence of first marriage of Sanjit Malakar. Prima facie, it appears from the evidence on record that the petitioner and OP, after their marriage, lived as husband and wife, out of which wedlock, 3 sons were born to them. Then Lordship kindly come to the next page, 263.
Yes.
From the above records, it is clear that railway authorities have committed an error in declaring Purnima Malakar as first wife, as it is against the observation made in para 34 by SDJM Fujai in the order of maintenance, order dated 16/12/13 to Srimati Purnima Malakar. The legality of the claim of the marriage with Purnima Malakar has been taken on the face value because on the declared date of marriage, she was only 14 years, 1 month and 22 days old. The agreement dated so and so, the marriage certificate dated so and so, and the birth certificate dated so and so are sufficient to come to the conclusion that Srimati Shimpu Malakar, the present respondent number 11, is the first wife of late Sanjit Malakar. Accordingly, all the pensionary dues and consequential benefits shall be paid to the applicant. To that extent, OA is allowed. Therefore, basically, it appears that, my lord, some declaration was given declaring her status as the first wife. And, my lord, the bone of contention, my lord, what we have raised, the tribunal is lacking jurisdiction. Tribunal cannot decide this question because marital status, any dispute regarding marital status between the parties is the subject matter of the civil court. There are a number of decisions on this point. That apart, my lord, we also apprise your lordship saying that since there is a suit pending, that part of the fact was not disclosed by respondent number 11 before the tribunal.
Did you in response bring this fact to the notice of the tribunal?
Pardon, my lord?
Did you in your response bring this fact to the notice of the
Yes,
tribunal?
yes.
Let us read that,
Yes.
please. Is that argument considered in the tribunal's order?
Contention to agree. My lord, may I, my lord, apprise your lordship that, my lord, at the time when we filed the OA,
Yes.
we did not have the knowledge.
Even you did not have knowledge.
I did not have the knowledge because I was not made party in the suit.
Okay, okay.
Then, my lord, subsequently, it has come to our notice. When, my lord, my lord, Champa Malakar, the daughter of my lord, respondent number 11,
Yes.
she filed an application for seeking impeachment. In that case, my lord,
In the OA.
in the OA.
Okay.
Oh, no, my lord. No, no. Yes, but in this writ petition, she made an application for imprisonment.
It's writ petition.
Yes,
Okay.
present writ petition. And my lord, in that writ petition, she, my lord, produced on records, plaint, etc., etc.
Let us see that pleadings, please.
Yes.
Implement. application.
Any number? My lord, lordship kindly come, IA number, my lord. Wait,
2286.
Yes, 2286.
Right.
Now, number in and para 4 at page 13. That the applicant humbly begs to state that her mother filed a suit before the learned Munshi Pujai, Shankar Dev Nagar, being title suit number 94 of 2014.
Is the plaint available on record?
Yes, my lord, it's available on record.
Plaint.
Yes.
Where is it?
Please. Like it. Quick print. Pure print, no? Oi. How do you copy down? Yes, go.
Page 37. 35 written statement.
Print the name. Print it. Set your word on. Hello, may I, my lord? Hello. Hello. They, my lord, produce on record the WS in connection with the suit,
Yes,
but unfortunately, my lord, I didn't find
the plaint.
copy of the plane.
Yes.
But I am the certified copy of my lord.
I'll produce the copy, my lord.
Have you copied the
The plate WS is at page 35.
Yes,
Yes.
WS page 35, which was filed.
Where's the plaint?
I have a certified copy.
Let us see.
One of the doctor. Donna. No.
Excellent written statement.
No, I have the copy, my lord. Personal copy.
Melody.
No, this is the. It will give.
Two copies of the plane, 2 copies of the WS.
WS is on record.
And there's a certified copy.
WS is already on record in the IA
On record.
at page 35. Suit for declaration of the plaintiff as legally married wife. उसके बाद क्या बचा?
Date of filing.
No, that was dismissed because he died. Suit abated. Suit abated.
Abated, my lord, to produce the WS, will it be a suppression of material facts?
Hmm.
In fact, it would have been for my advantage. My lord,
Irrespective, irrespective.
I'll argue.
Yes. All right. You may continue, Mr.
Yes, my
Prakash.
lordship, kindly have a, my lord, my lord, relief sought for in the suit. My lord, at
The
page
suit is for a declaration.
declaration.
We have seen that.
He is the, my lord, wife. And second relief sought for is, my lord, that there be a declaration directing the defendants to take necessary steps to enter in the name of
Yes.
so and so and so. Our name is yet to be, my lord, enter in the service record. And my lord, relief number 2, declare that the plaintiff is entitled all the rights about the property. And my lord, what I say, my lord, proper pension is also a property. Therefore,
Yes.
she is still in doubt, my lord, whether she has got any right to, my lord, inherit the property. Therefore, she sought for a declaration.
Yes.
And lordship, kindly see the, my lord, date of filing, very beautiful. 18th of September 2014.
And when was the OA filed?
We filed, my lord, in the month of September 2015. After 1 year. Therefore, my lord, other days, my lord, I have placed on record some decision
Please.
saying that the person who is not in clean in hand, suppressing certain material fact, she is not entitled to get an equitable relief. On the other hand, my lord, unless and until she gets a declaration, there is no any question to project herself to be the, my lord, wife of so and so. And she also cannot claim to have any right of inheritance. Because declaration is yet to be, my lord, given by the court. Therefore, on that point of view, my lord, the order itself is not maintainable in law.
Hmm.
Because it is a sublimit of the civil court, that civil court decide the matter, that civil court decide who is the first and second wife. And in the same
What-
time, my lord,
What is the law you are relying on?
yes, my lord. Same copy. Yes. My lord, I have given some decision, my lord. And
Doesn't matter.
the
Yes.
first decision, my lord, in this regard is the Kerala High Court,
Yes.
referring to decision of Supreme Court, my lord. In that case, it is a sublimit of the civil court or family court. Where there is a family court is the only competent court to decide the marital status, otherwise civil court.
Yes.
My lord, at page of that particular judgment, page of page was, para 16, my lord, of that judgment,
Yes.
my lord, in the middle portion, last line of para 16.
Yes.
My lord, therefore, I am of the view that civil court had the jurisdiction to decide this suit, and that decree is not a nullity. Therefore, whether she is a first wife or second wife, whether my marriage is a nullity or their marriage is a nullity, this question has to be decided by civil court.
Yes.
That part, my lord, the basic fact they, my lord, brought on record, saying that there was an agreement in 1997. And they say, though my marriage was subsequently registered under the Special Marriage Act, therefore the marriage has to be treated to be a marriage with effect from 1997.
Hmm.
But I, my lord, raised, my lord, the question other days, my lord, apprising your lordship that in view of section 18 of the Special Marriage Act, marriage shall be deemed to be a marriage with effect from date of registration.
Date of registration.
On the other hand, my lord, it is a admitted fact. She belonged to, my lord, Muslim religion,
The respondent.
respondent.
Okay.
And my lord, it will lordship will find from the judgment of my lord MRTs, 70/2000, my lord, 12. There is an evidence adduced by her saying that she was a Muslim
Yes.
Then if she is a Muslim, then
Yes.
her marriage cannot be governed and regulated by and under the Hindu Marriage Act.
Hmm.
Because there is a specific provision under section 2, explanation C,
Yes.
unless and until there is a convert or reconvert,
Hmm.
there cannot be any marriage under Hindu Marriage Act.
Yes.
Therefore, if the marriage is said to have been solemnized in 1997, that marriage has to be solemnized under the Hindu Marriage Act.
Yes.
And as per the Hindu Marriage Act, since she was not converted, because my lord, the agreement which their affected relied on doesn't reflect that there was conversion, she became Hindu, and thereafter marriage took place. Therefore, on that point of view, also marriage is not, my lord, sustainable in law.
Mm.
On the other hand, madam, I married the Sanjit Malakar in 1999. And marriage was registered under the Special Marriage Act in
Yes.
between the respondent number 11 and Sanjit Malakar in 2010. Therefore, in view of section 18, marriage has to be allowed solemnized with the effect of date of registration.
Yes.
And Supreme Court says, my lord, section 18 is a mandatory.
In which judgment?
On that judgment, I don't have any at this point because the settled position of law, my lord, section itself will show. I'm just reading for your lordship appraisal. Effect of registration of section 18. Special measure.
Special Marriage Act.
May I read, my lord?
Yes.
Effect of registration of marriage under this chapter, subject to the provision contained in subsection 2 of section 24, where a certificate of marriage has been finally entered in the marriage certificate book. Under this chapter, marriage shall, as from the date of such entry, be deemed to be marriage solemnized under this act. Therefore, they cannot take the advantage of that. See, though there is a recital in the marriage certificate that there was a marriage taken place between the parties in 1997. Now, Lordship, kindly have a look of the agreement.
Page.
Well, I'm showing you, Lordship. Page copy.
Page 69.
Page 69.
Yes.
Page
69.
page 69 type copy, or we have also annexed the photocopy of the original copy.
Yes.
My lord, at page 69, annexure 1 of OA,
Mm.
the parties, I'm just reading the, my lord, terms and condition.
Yes.
That the parties referred above to are measured and are eligible to enter into marriage deed. From that very, my lord, expression or sentence, if you read the entire sentence as a whole, they, my lord, they are eligible to enter into marriage deed. Therefore, it cannot be said that there was a marriage on that day. Next, my lord, para. The first party has accepted the second party as his lawful wife, while the second party also accepted the first party as her husband. Look, can anyone, on the basis of this statement, claim to be legally married wife or legally married husband? Supreme Court says, my lord, I have referred this judgment and show your lordship that unless and until,
Ceremonies of marriage.
yes, section 5 is complied with. That is section 7 of the Hindu Marriage Act.
Yes.
There cannot be any marriage in the eye of law. Therefore, my lord, this agreement cannot under any circumstance, even by stroke of imagination.
Under
We
Hindu
say-
law, marriage is not a contract.
Yes.
Yes.
Therefore, marriage under the Hindu law, lordship knows it is not a contract. It is a, my lord, sacrament.
Yes.
Unbreakable, my lord, marital
One of the
relation.
arguments may be that if there was a marriage as per Hindu rites and ceremonies, rituals, there was no necessity for registration.
Exactly, exactly, my lord.
Yes,
And my lord, immediately after section, my lord, 2010,
Yes.
my lord, they cropped up. They brought all this thing. Lordship has, my lord, I will point out one thing. I will take your lordship to one particular document,
yes,
which is uncontroverted. And earlier authority also admitted that fact. My name appeared in the service book, my lord, in 2001.
2001.
1 to 2007, there was no any objection raised by anybody.
Mm.
And she made an application subsequently to get her name entered. And authority says her name did not enter. Therefore, my lord, she is not a nominated legal heir. Therefore,
Yes.
she does not have any right to claim any, my lord, legal heirship or to get any right to get this, my lord, pensionary benefit of Shanjit Malakar unless and until suit is, my lord, ultimately decided in her favor. Parallelly, my lord, tribunal cannot decide that question.
Yes,
Time and again, Supreme Court says it is subject of the civil court or family court to decide the status between the parties. Therefore, my lord, status, even if any declared by tribunal, that is of no significance in the eye of law.
yes,
Therefore, my lord, the OA may be, my lord, the ordered person OA may be set aside. Or matter may be, my lord, directed to be dealt with by the railway authority in accordance with law.
yes,
Because already there was an order, my lord, for release of the pensionary benefits. Then, my lord, one more judgment, my lord,
yes,
my lord, 2009, 1 SCC 714. Second judgment, my lord, in the
Yes.
compilation. It is says that section 5 is mandatory.
Mm.
Now, unless and until, my lord, the marriage took place in accordance with section 5, whereas in
yes,
section 7, there cannot be any question to constitute a particular marriage to be a valid marriage. I'm just referring to next page, Lordship, kindly have a look. It is held that, next page, my lord, reverse side. The preamble to Hindu Marriage Act 1955 itself indicates that the act was enacted to codify the law relating to marriage amongst Hindus. Section 2 of the act, which deals with application of the act, reinforces the said provision. Section 5 of the act thereafter also makes it clear the marriage may be solemnized between any two Hindus if the conditions contained in the said section were fulfilled. The usage of the expression may in the opening line of the section doesn't make the provision of section an optional. That means it is mandatory, my lord.
yes,
And on the other hand, the Hindus, if the conditions indicated were fulfilled, in other words, in the event the condition remain unfulfilled, a marriage between two Hindus could not be directory as has been sought to be argued, but mandatory and non-fulfillment of thereof could not permit a marriage under the act between two Hindus. Section 7 of the 1955 Act is to be read along with section 5. In that, a Hindu marriage as understood under section 5 could be solemnized according to ceremonies indicated therein. As your lordship knows, my lord, nuptial prayer and seven steps. These are the two basic requirements under the Hindu law. In every, my lord, Hindu customary practice and tradition, my lord, these are the two steps which is said to be a religious ceremony are to be observed
yes.
by the parties.
Yes, please.
My lord. Even lordship, my lord, one decision in 2011, one SCC. 9. My lord, one SCC, lord, it is on compilation, my lord. 141. 9 number.
Yes,
Judgment number 9.
yes,
That presumption, there cannot be any presumption.
regarding,
Long Pardon, my lord.
regarding
Regarding my lord, long cohabitation. Non-cohabitation cannot be the basis.
Chanmonia.
Yes, my lord.
Yes,
Cannot be the basis to declare a person to be legally made wife or husband.
yes. Hmm.
And lordship, my lord, one judgment I had referred to, back to refer, my lord, judgment number 11.
Yes,
I have pointed out that, my lord, number of decision of the Supreme Court is referred to, saying that pension is a property. And she sought for a declaration that she has a right to, my lord, right over the property. Therefore, pension is a property unless and until that declaration is, my lord, obtained by her in the civil suit, question doesn't arise.
Administrative Tribunals Act. This is a blog. At serial number 11, it's just a blog. It's not a judgment.
No, there is a, my lord, reference of, my lord, Supreme Court judgment.
Yes,
Nolini Gopal versus Union of India.
it's Bombay High Court judgment.
Yes.
Yes,
Law is, my lord, universal, and it has got a uniform application. My lord, in all the high courts sanctified the legal proposition of law. And my lord, judgment number 12. My lord, what I am trying to impress upon lordship, and lordship other days, my lord, also pointed out that once there is separation of material facts, knowing well, it is you who filed the suit. I could understand, my lord, somebody else filed the suit. She might not have the knowledge, but she is the plaintiff, and she is suppressed the material facts. Now, in that regard, my lord, 2004 amnesty, 166,
2000.
2004, judgment number 12,
Yes,
separation of material facts.
yes.
Paragraph 13, my lord.
Yes,
As a general rule, separation of material fact by a litigant disqualifies such litigant from obtaining any relief.
yes.
Then, my lord, one more judgment, 2010, 2 SCC, judgment number 14, page 114.
Yes,
My lord, while referring to procedure and practice and procedure, said that if the litigant is dishonest and he has to be strongly deprecated, and the procedure so adopted, my lord, because of non-disclosure of facts, ultimately it is disclosed, then it will amount to abuse of process.
yes.
So, my lord, in some substance, my lord, ultimately, my lord, it boils down that since the tribunal had decided the matter exceeding the jurisdiction, declaring the marital status, the order so passed is a nullity. It cannot have any legal significance. Even court doesn't have any, my lord, judicial discretion to re-examine the matter.
Yes,
On the very face of it, my lord, it is illegal. No. That's right. এটা কত 8-1 একটা চ্যালেঞ্জ ছিল না 8-1 8-1 এর প্যারা কত ছিল 8-1 কত? ওই যে তোমার ওই যে ছিল ইয়ে যে ছিল তোমার এই যে 2081 থেকে 2007 পর্যন্ত যে ইয়ে করছিল আছে তো ওই পেছো My lord, lordship kindly, my lord.
Be within 4 minutes. Unless the declaration is there. Yes.
My lord, kindly, my lord, have a look, my lord, at page 87
Of,
of my lord, writ petition.
yes.
Like it will reflect that the name of the petitioner was nominated by the
There is no
husband.
dispute.
There is no dispute.
about that. Yes.
And they said it is a fraudulent and mischievous, my lord, favorable report in favor of the petitioner. That was the
Yes.
contention they have made. And learned friend, my lord, they have also filed a separate writ petition on behalf of the railway. And my lord,
But Mr. Prakash,
my lord,
even this document you are relying upon, it says Purna Lakshi Malakar.
my lord,
So how it is the petitioner?
Purnima Malakar.
Read para 2.
Yes. Staff concerned.
Para 1. As per records of the family declaration
Purnima
submitted by the
Malakar.
staff, Srimati Purnima Mali,
Yes,
not Malakar.
my lord,
Then para 2,
my lord.
wherein his wife's name was Purna Lakshmi Malakar.
Wife. And to the next time, there was an affidavit, the same and one and same person. In 2010,
2010.
yes.
Where is that document?
May I pass it on, my lord?
Yes. What is that?
My lord, there is an affidavit, my lord, shown by the petitioner herself. There is a, my lord, discrepancies in regard to her name, but actually, she is one and the same person.
Very well. Anyhow, that if at all we decide the matter in your favor, that would be for the railway authorities to consider.
My lord,
Yes.
my lord.
Yes,
Therefore,
please.
Yes, my lord. Therefore, my lord, lordship will, my lord, be satisfied that, my lord, the tribunal doesn't have jurisdiction and tribunal exceeded, my lord, in access of jurisdiction not vested. And that's why, my lord, they assumed the jurisdiction of the civil court, deciding this status of the respondent number 11 and the order passed on that, my lord, findings, which is not authorized,
Yes.
has to be, my lord, satisfied.
Very well.
My lord,
Yes.
if necessary, my lord, I may be given the chance to reply, my lord.
Of course. That would be rejoinder, sir. Yes.
May it please, Your Lordship. My lord,
Yes.
to appreciate this matter in the proper perspective, my lord, some facts would be necessary.
Yes.
Now, my lord,
First question you have to answer is regarding concealment of fact.
I'll answer all the
You address the court first on that aspect,
questions.
then we'll see, we will consider your other.
First, I'll address your court.
Yes.
As your court desires, my lord. Lordship, if your lordship takes up the plane for a moment, my lord.
Yes. What's the title of the plaint?
Yes. My lord, before I read the plane, for a fact to be a suppression of, or a material fact, which is considered to be suppression,
Yes.
my lords, that suppression should aid the person who has suppressed it any benefit against the other party. Now, lordship would see what does the plain
Yes.
phrase formulas in the plain.
Yes.
My lords, I'll directly come to the prayer,
First, the subject matter.
subject matter. A suit
Yes.
for declaration of plaintiff as legally married wife of the defendant.
Now read para 1.
Yes, the plaintiff being the legally married wife of the defendant is entitled to get every right over the person and property of the defendant and is of the defendant.
Yes.
It should be in, my lord, in the subject
Yes.
matter of the suit. That on 27/11/97,
Yes.
the plaintiff and defendant executing a court affidavit solemnize nuptial ties between them with Hindu
Yes.
rites and customs when both of them were major in the age.
Yes, all right, we have read that. Now
My lord, lordship would come to the WS now for a moment.
WS. Yes.
I'll read paragraph 2, my lord,
Yes.
that the averment made in paragraph 1 of the
It's an admission.
admission.
Understood.
It's an admission.
What is the consequence of the suit being decreed? Just hold on, sir.
I'm so sorry.
What is the consequence of the suit being decreed? She was undoubtedly nominated by the employee, right?
No, my lord.
No, she was not nominated.
She was nominated, it was cancelled.
Maybe she was nominated, it's a fact.
Yes.
When was the cancellation order passed?
Cancellation, well, it's a by way of a legal fiction, my lord. It has
So there is no express cancellation as such.
I would say it's an express cancellation by virtue of the rules. I'll come to that. Lordship would kindly hear me, my lord, on that.
We are asking you a question.
Yes.
What is the date of cancellation of a nomination?
It has to be construed to be date of cancellation of the nomination would be, my lord, in the year 2014, my lord.
14, right? What date precisely?
The exact date would be 25/03/2014.
2503. All right.
Didn't find it.
Where do we get it from?
My lord, Lordship would find it in page, but before that, Lordship has to peruse the rules, my lord. The
Mr.
85,
Counsel,
85,
Mr. Counsel, we are putting you a particular query.
85,
Please answer that query as such.
my lord, page 85.
Yes. Where do we get that date from?
Page 85 of the petition.
That date you are talking about,
That date.
85, yes. What is that? Yes,
To the Chief Health Inspector in charge, Lamding, NF Railway Lamding Division at Lamding, Nagaon, dated 25/03/2014. Subject reminder letter submitted of
so
submitted
this is
declaration.
an application by the employee to include the names of his two more family members, right? There can be more than one nominees, no dispute, right? So he says, include the names of two more of my family members in my nomination form, right? Any order passed on that?
No order.
No order. So as on the date of filing of the suit, there was no cancellation of the nomination of the respondent as such.
I would say there was a cancellation. I'll come to that.
Okay,
No
very,
cancellation. My,
very well.
and my lord, if I may kindly submit, my lord.
Yes,
My lord, it's not that they are replacing, my name was replaced by, added to the nomination, my lord. It was replaced by my name. Lordship would see the
Okay.
nomination on the next page,
that is the
Page
form
80.
filled by the employee.
employee,
Yes.
in the statutory form.
Does the employer accept this form?
Yes, he has to. He must.
Has it been accepted, gentlemen? No.
No.
All right.
It was not even challenged.
Okay. So you say that that is a deemed acceptance. Okay. Let us see your pleadings in this OA.
Mm.
Let us see.
OA, my lord, the lordship would come to page 53, where the OA
Yes.
starts, my lord.
Yes.
Paragraph 4.15, my lord.
Yes.
Just. Okay. I'm so sorry, my lord, 4. Lordship would just give me a moment, my lord.
Yes.
Page, yes, wasn't it? Annexure 18. My lord, page 58,
Yes.
paragraph 4.4 and 4.5.
Yes.
May I read, my lord?
Yes. Yes.
The humble applicant applied to the respondent number 8 on 2/6/15, praying for granting all service benefits to
Yes.
the humble applicant as she is the legally married wife of Sanjit Malakar, but no
Yes.
reply has been received from the respondent number 8, though the humble petitioner and her daughter are starving. 4.5. The humble applicant's late husband submitted a reminder application on 25/3/14
Yes.
regarding his application dated 27/04/12 in connection with his family members, late Sanjit Malakar, showing his declaration of family members in the annexure sheet of the application dated so and so, Sanjit Malakar himself
Yes.
stated that Sipu Malakar, Champa Malakar, daughter born so and so, submitted a reminder application with annexure of a family declaration.
Yes, yes.
So that was specifically pleaded.
Very well.
My lord, I may submit, my lord. My lord, the petitioner in the instant case, he has to stand on his own feet, my lord, to prove his case. Now, has he produced a single document whatsoever? At least I have,
Petitioner's argument is simple.
my lords.
She is the nominee in the service records. No dispute about that. And the tribunal has no jurisdiction to decide the matrimonial status of two persons fighting over that status. That is the argument. Let us restrict it to that. Answer that query.
I'll address the second issue, my lord, that the
Yes.
tribunal is not vested with the power
Yes,
to declare the marital status of person.
Yes.
Well, first of all, the tribunal did not endeavor to make a declaration on the marital status. What the tribunal had done, my lords, there was an order by the respondent railway. Respondent railway, there was an order which I would say was highly partisan, my lord. It said, my lord, which is perverse, I'll come to that,
yes,
that the petitioner is the first wife, basing that claim on a judgment, on a misreading of a judgment passed in a
yes,
maintenance application, and thereby granting all the benefits, pensionary and family pension,
yes,
to the petitioner.
yes, yes.
Now, after that order was passed, the respondent had no other alternative but to approach the learned cat. Now, my lords,
Yes.
on the last occasion, I had placed a judgment by the Honorable Supreme Court that would precisely answer this point, my lord.
Yes,
My lord, the judgment which deals with service law under similar circumstances, it had held, my lord, that in a matter especially pertaining to pension,
yes,
where there are claims of two wives,
Hmm.
the administrative authority would have the right to carry out a inquiry and find out that who's eligible for receipt of.
the administrative authority.
Yes,
The
yes.
question is tribunal.
I'll come to
Yes.
that now.
Yes,
My lords, they would have the authority, to find out that who's actually eligible, sans the provision of there being you can relegating them to a civil court. Because
Yes.
the underlying principle is that they can go to the
the
civil court.
administrative authority decides arbitrarily as per you. Whether the tribunal has the jurisdiction, sir. Question here is,
Yes,
Yes.
I'll answer that.
yes,
My lords, so as per the judgment, the administrative authority, without waiting for the judgment passed in a civil suit,
yes,
can always come to a finding that
yes,
who is the first wife and who is the second wife.
all right,
They can have a finding. Now, once there is a finding made, what is the remedy available to the person who's agreed? He has to approach the tribunal because it's a central government. Otherwise, the High Court. He had to approach.
a finding on the status of marriage. The remedy is to the tribunal. Are you sure?
Well, what
Read the Administrative Tribunals Act, sir.
Yes, ma'am.
Read, please.
Yes,
First
what-
satisfy us on that.
What I'm trying to, my lords, I'm sorry, I'm not being able to. What
Maybe
I'm
you are
trying to-
very clear. You are very clear,
what-
but
what-
we are not clear. Please satisfy us. Where does the party go against such an arbitrary order of the tribunal, of the administrative authority? Read section 14.
Jurisdiction, powers and authority of the central administrative tribunal. Save as otherwise expressly provided by this act, the central administrative tribunal shall exercise on and from the appointed day all jurisdiction, powers and authority exercisable immediately before that day by all courts except the Supreme Court. A, in relation to recruitment, matters concerning recruitment to all India services, services to any civil services, union or a civil post under the union or to a post connected with defense or in defense services, being in either case a post filled by a civilian. All service matters concerning a member of All India service, a person not being a member of All India service or a person referred to in clause C appointed to any civil service of the union or any post under the union, a civilian not being so-and-so or a person referred to in clause C appointed to any defense services or to a post connected with defense and pertaining to service of such member, person or civilian in connection with the affairs of the union or of any state, of any local or other authority within the
Yes.
territory of India under the control of the government.
So
of
under
India.
which clause of this provision can you claim relief?
Well, C, I'll read C.
Yes,
All service matters.
yes.
Okay.
So what is the service matter involved now? There's no dispute that pension would accrue.
My lord.
Who would get the pension? Is it a service matter?
My lord, because that.
Very
Then, my lord, the appropriate remedy, if not the tribunal, my lord, I'd ask myself this question, my lord.
Yes, you ask yourself,
My lord,
yourself the question and try to
what-
give
what
the
would have
answer.
been- What would have been the proper remedy? Because
Yes,
all pension matters, my lord, even in the high court and
there is no dispute about pension, sir.
my lord.
Pension would accrue. Pension has been sanctioned. Who would get the pension? Whether that is a service matter.
My lord, since the pension itself is an outcome of
Property rights,
my lord.
right?
So, my lord, the submission made by my learned friend, my lord, I would disagree that pension.
Of
is a-
course you will
pension is-
disagree.
Pension is a property, my lord.
Yes,
Pension is not a property, my lord, insofar as family pension is concerned, because number of judgments starting from Violet Isaac and other judgments of the Supreme Court has clearly held that insofar as family pension is concerned, it cannot be made subject of a testamentary instrument.
Hmm.
It is not a property of that person and it would only devolve as per the family pension rules.
yes,
Now, for example, my lord, if in the family pension rules, family has been defined, any person outside the family cannot be, my lord, granted the family pension.
yes.
And if there's none of those members alive, then no one would be eligible to receive the family pension.
Yes.
Now, my lord, I'll quickly take your lordship to the impugned order, which was impugned in the, my lords,
OA,
my lord.
197.
197. my lord.
Yes,
196 is the impugned order, my
Yes.
lord. I'll come to 196. Facts of the case, on scrutiny of the service records of late Sanjit Malakar, it was found that Malakar was appointed to railway service and so and so, so and so. I'll skip the second, third, fourth, fifth paragraph. My lord, there are 2 points, issues which are, my lord. One,
what is the final outcome of the order, please?
my lord,
Yes.
point 1, whether the petitioner is the legally married wife of the opposite party. Second,
Hmm.
whether the petitioner and the minor children are entitled to the monthly maintenance.
Yes,
Point number 1 and 2 have already been decided by the honorable court in affirmative against OPC Sanjit Malakar, and honorable SDJM Sankadev had passed an order to pay monthly maintenance of so and so. The petitioner Purnima Malakar as
so there were only 2 issues, right?
my lord,
Issue number 2 need not have been decided.
my lord.
Issue number 1 was regarding status of marriage.
Yes, my lord.
Okay. Now just please, again, go back to section 14 and tell us that the tribunal has jurisdiction to entertain such a dispute.
Section 40.
This is the order you challenged before the tribunal.
Yeah.
Right?
Yeah.
What is the conclusion of this order? Whether that can be subject matter of challenge by resorting to section 14.
It can, yes, my lord. Yes. The conclusion
Of
is
course,
from-
your argument would be, can be. In what manner?
from the judgment of the honorable so and so, it reveals that Sri Sanjit Malakar legally married Purnima Malakar and so of the marriage certificate. It is noted that the marriage of Sanjit Malakar with Sippo Malakar was held on 27/11/97.
So, right. Right, okay.
And they were
Now
living,
the tribunal will formulate these issues that whether the marriage of Sanjit Malakar and Purnima Malakar was valid or not, or whether Sipo Malakar is actually the legally wedded wife of Sanjit Malakar. That is upon the tribunal to decide. You want us to affirm this finding?
My lord, because for the purpose of payment of pension, that issue has to be decided, my
Gentlemen,
lord.
11.915 doesn't at any point say that the officer was deciding the issue regarding pension. There was nothing in that order.
My lord, this order, my lord, the inquiry which I'm referring to.
Yes.
But that is, my lordship would then pursuant to this inquiry, my lord, the impugn order.
So
is
first,
page
firstly,
190,
sir, answer
my lord.
whether 11.915
Yes,
could have been examined by the tribunal. Validity thereof.
my lord, in by virtue of the impugn order, which was the result of the inquiry, 11.915, my lord, yes, my lord, because it gave a right to the petitioner to draw the pension.
Yes.
And my lord,
Okay.
since
So
pension is,
next question,
my lord,
rival claims over pension. Whether the tribunal is the appropriate forum to decide. Tell us, give us one judgment on this.
my lord, this issue about first wife and second wife, my lord.
No, rival claims on pension.
Right.
There may be so many situations.
Mhm.
Mother, daughter-in-law, two parents. There may be situations. Give us one judgment.
My lord,
That
violet I
rival
said,
claims of pension can be adjudicated by the tribunal.
it's done, my lord. I have one, my lord, but there are numerous, my lord. In fact, this honorable high court has a plethora of judgments, my lord, where
Let us see.
the court has decided whether who's entitled. Because to decide that, the court-
Tribunal, CAT,
Well,
not this court. Writ court has the jurisdiction.
that tribunal also has the same power, my lord.
Well, oh.
That I'll tell you, I'll show the administrative.
Very
tribunal,
well, very well.
my lord. Save as otherwise expressly provided in this act.
Yes,
The Central Administrative Tribunal shall exercise on and from the appointed day all the jurisdiction powers and authority exercisable immediately before that date by all courts. Except Supreme
yes,
Court.
yes.
If the High Court can adjudicate.
In relation to, we'll forget this is the title of the section. Header. In relation to what?
In relation to service matters. That's what in relation.
Okay, sir. Now, once again, the same question. What is the service matter involved in this? Yes.
Service matter, my lord. Service matter, what is involved in my humble submission, my lord? Because
Has the railways denied pension to anyone?
yes, they're
Denied pension.
Denied pension to my client, my lord. That is why I went to the tribunal.
Okay,
my lord.
very well. You can conclude your arguments. Very well. Yes,
My lord, Lordship would take up the rules for a moment.
yes. Rules of,
The railway service pension rule.
yes. Yes,
I have marked the pages, my lord.
yes.
Page number 8, my lord.
Yes,
Rule 70, retirement gratuity or death gratuity, my lord. If a railway servant, my lord, I'm not reading the entire paragraph, my lord.
yes,
Rule 70 at the bottom, my lord, page number 8.
yes,
B. If a railway servant dies while in service, the amount of death gratuity shall be paid to the family in the manner indicated in the table below. That is not relevant, my lord. Lordship would turn the page and come to 5, my lord.
yes,
For the purpose of this rule,
yes,
Rule 71, 73, 74, family in relation to a railway servant means, I'll pause here for a moment, my lord. This lordship would kindly note that the meaning of family assigned to gratuity is different. And later when I show my lord, the meaning of family assigned for payment of family pension is different.
yes,
My lord, it says wife or wives, including judicially separated wives or wives, so and so, the husband. Here, my lord, children of predeceased son is also entitled. 71, persons to whom gratuity is payable. Gratuity is payable under section 70. 70 shall be paid to a person or persons on whom the right to receive gratuity is concerned by way of making a nomination under 74.
yes.
So as per the nomination, the persons within the meaning of family would be entitled. 2, The railway servant dies, not required, my lord. Lordship would come, turn the page and come to nomination, my lord,
Yes.
74. A railway servant on his initial confirmation in service or post, make a nomination in Form 4, conferring on one or more persons the right to receive date come retirement gratuity payable under 17.
Yes.
Provided that if at the time of making the nomination, the railway servant has a family, the nomination shall be in favor of the persons other than the members of his family or so and so, so and so. Lordship would come to 5. This is important, my lord. Next
Yes.
page 12. 5. A railway servant
Yes.
may at any time cancel nominations by sending a notice in writing to the authority mentioned in sub-rule 7.
Yes.
In the instant case, my authority would be the person to whom I have made the, provided that
Yes.
he shall, along with such notice, a fresh nomination has to be made in accordance with him.
Yes.
So the rule prescribes, my lord, that I can cancel anytime my nomination, earlier nomination, provided I also provide the fresh nomination whom I nominate,
Yes.
my lord.
Yes.
My lord would come to 7 for a moment, my lord. Next page
Yes.
of 7A.
Yes.
Every nomination and every notice of cancellation given by a railway servant under these rules shall be sent by the railway servant to his accounts officer in case of a gazetted railway servant and to the head of his office in case of a non-gazetted railway servant.
Yes.
So I'm a Safai wala, my lord. I ought to have sent the application to the head of my office, which I did, my lord.
Yes.
8 is very important, my lord. That's why I say, my lord, every nomination made and every nomination of cancellation given by the railway servant shall, to that extent it is valid,
Yes.
take effect from the date on which it is received by the authority mentioned in sub-rule 7.
Yes.
So there is no requirement of any formal order. My lord, it's the same as in a voluntary requirement. The time limit is
Yes.
given if no order is passed. Now
Yes.
it takes effect from the date when the
Yes.
and the fact that
Yes.
the cancellation, well, that may not be termed in so many words as a cancellation, but
Yes.
nonetheless, the document has to be construed to be a cancellation. Now, my lords, to show that that was duly received by the railway authorities,
Yes.
I would again take your lordships to page 197 for a moment, my lord. Page
Yes.
197.
Yes.
Page 197, 198, my lord, next page. The
Yes.
third paragraph, in the year 2014.
Yes.
In the year 2014, Sanjit Malak again submitted his family declaration whereby the name of Sippo Khan alias Sippo Malakar and her daughter Champa Malakar were mentioned, but he did not nominate Sippo Khan alias Sippo Malakar by giving notice for cancellation his previous nomination and declaration against Purnima Malakar.
Yes.
This finding is totally perverse. I gave a application, I changed my nomination, that was
Yes.
not adhered to in the year 2012.
Yes.
Then I again give a reminder that 2012, I sent you a fresh nomination, you accept it. They acknowledge the fact that nomination was sent. Now, in my humble submission, as per the rules, the nomination would take effect from the year 2012.
Yes. Yes.
Now, insofar as
The
the
nomination only gives rise to claim of gratuity,
gratuity.
right?
Of course.
Where is the prayer in the tribunal for gratuity? Read the prayer.
My lord, in my OA,
Yes. Yes. Endorsed in the records.
8.3, page 66. my lord.
Yes.
As the humble applicant is the legally married first wife of late Sanjit Malakar, so and so she is entitled to give funeral assistance, it should be to be given. Family pension, GIS, leave salary, DCRG, compassionate ground appointment and pension manual, so and so.
Gratuity,
DCRG is gratuity, my lord, death come retirement gratuity.
death come retirement. Okay. Very
So
good.
my lords, insofar that one aspect is very clear, my lord, from the
Yes.
rules, that insofar as payment of gratuity is concerned, in the year 2012 itself, the name of my client and my
Yes.
daughter should have been replaced, my lord. Even if it is not done by way of a formal order.
Is there a procedure for replacement?
Yes, I'll show it again. I'll
Yes.
take up the rules again.
Or, and whether there was any prayer for replacement? No. In the application? No.
My lord,
Whether there was any prayer by the government servant to replace?
lordship has to construe the application, then come, Lord, I'll read the.
Read the application, yes.
application. First, lordship would peruse 86.
Yes.
This is the form in the statute, is the statutory
Read
form.
the application first,
Hmm.
page 85.
Reminder letter of submitted declaration of dated so and so in respect of family members of Sri Sanjit Molakar, designation SFLA so and so in the office of the Chief Health Inspector Lamding. Sir, with reference to the subject cited above, I have to inform you that I have submitted my family declaration of the members of my family as a railway employee on so and so, wherein I have mentioned my name, Sanjit Malakar, my wife's name, Sipu Malakar, and my daughter's name, Ms. Champa Malakar, as my family members under the provisions of
Yes.
the railway administration rules. But your authority has not
Not
included.
included.
Yes.
Yes.
My lords, this application, my lords, it may not be semantically perfect, my lords, but nonetheless, it has to be construed. That person gave a letter. He said, you add my wife.
Yes.
It cannot be construed to say you add names of two wives, names of three.
So naturally, the railway authorities, when they already have information regarding one wife having been nominated, why would they nominate another? Why would they do that? If they didn't do it, what is the remedy?
By way of the deeming provision.
Whether refusal to nominate is a service dispute,
My lord,
whether refusal to nominate or inaction on a nomination request, it is a service dispute.
subject to correction, my lord.
Yes.
My lord, because this
well.
nomination itself is part of the service.
Okay, very well.
And my lords, just one more thing, my
Now
lord.
you may conclude in 5 minutes. We have given you enough time. Yes.
So insofar as the payment of DCRG is concerned, my lord,
Yes.
there was a notice, and by way of that deeming provision from that day itself, my name should have been included. Now,
Yes.
lordship put a very pertinent question.
Yes.
Can there be two wives? Well, as per the railway rules, yes. It envisages such a situation. my
Yes.
lord.
Yes.
I'll take your lordship to the rules again.
Yes.
First, my lord, page number 9. Won't take much time, my lord. Finish
That
this
would
page.
mean legally wedded wives.
My lord, there cannot be two legally wedded wives, my lord, because it's a payment of pension is, in my
Yes.
humble submission, a beneficial legislation. And that is
Yes.
the reason why, my lord,
Yes.
these are included.
There is nothing like the wife who is not legally wedded. If not legally wedded, the term would be different, which we are not now permitted to speak.
My lords, it does not use the word legally
Honorable
married.
the-
Nonetheless, I'll read it out. my lord.
Yes.
5.1, wife or wives, including judicially separated wife. That's the meaning of family. I'll skip the
Yes.
later parts and directly come to, my lords, the family pension rules.
Yes.
Page 18, my lords, 7.
Yes.
It's part of rule. Which is part of rule
Yes. Yes.
7.
Yes.
It says where the family pension is payable to more than one widows, more widows than one.
Yes.
The family pension shall be paid to the widows in equal shares.
Okay. Yes.
So I have shown the rules to my lords, my lord.
Okay. Very well.
My lords, now coming to the point of marriage, my lord,
Yes.
there is a, my lords, first of all, my lords, my learned senior friend has submitted that none of the ceremonies took place, none of the ceremonies took place and there was no marriage, Hindu marriage required. And that was the precise reason why we registered our marriage before the Special Marriages Act.
Yes.
Lordship is aware that post pre-colonial times, my lord, before the Special Marriage Act, there was the Hindu Marriage Act. And because of such difficulty, intercaste marriage, inter-religion marriage, everyone can opt for a special marriage.
Yes.
And the special marriage, my lord, is a legal transaction. It's
Yes.
not like a sacrament as per the Hindu law.
Hmm.
So no ritual or ceremony per se is required.
Yes.
I am a Muslim. I in any case could not have, my lord, been married
From the,
as per the Hindu marriage. Act.
as per the Hindu marriage. Act.
As per the
Yes.
Hindu marriage. So therefore, my lords, therefore, we got married, and since no ceremony is required, that has to be considered with effect from 2007. Now, few
Yes.
facts here, my lords would kindly consider, my lords.
Yes.
My marriage, the undisputed, my lord, lordship would take note of the date on
Yes.
27/11/97.
On the basis of agreement.
That is
On the
not
basis
the
of-
undisputed date, sir.
Well,
They have seriously contested that there was no marriage at all.
no marriage.
Yes.
The agreement is, my lord, there. It's signed by a magistrate, my lord.
Maybe,
Yes.
maybe.
Agreement, I'll refer to as an agreement. my lord.
Yes.
Marriage agreement, if I can call it, my lord, is dated 27/11/97,
It's a worthless piece of paper.
worthless.
Yes.
20/01/1999, 20/01/1999, Champa Malakar was born, who's my daughter. That
Yes.
has not been disputed till date that she's my daughter.
Yes.
Daughter dispute person. I couldn't find it in the pleadings till now.
Okay.
That my daughter, I have a birth certificate of my daughter.
Yes.
That has
yes.
not been disputed. On 1/10/1999, after my daughter is born, purported, I use that word purported, second marriage was conducted.
Yes.
And my lords,
Now, that question is also subject before the trial court regarding, my lord, the parentage of the girl. my lord.
There's
Whether
a
she
suit
is-
going on. So pending suit.
Yes, yes.
Which one?
My lord, we have also filed a suit.
Okay. Very well.
Subsequently, when you came to know that suit was filed, my lord, without impeding me as a party in the suit. Then we filed a suit.
when my learned friend rejoins, my lord, lordship would give me 5 minutes. I'll
Now your
the
5
exact
minutes are
Exactly.
reduced to 2 minutes now.
Yes.
Yes.
1/10/1999, Purnima Malakar, after the birth of the daughter, my lords. Admittedly, my lords, the date of birth of Purnima Malakar was 9/8/1985.
Mr. Counsel, at best, it can be construed that Champa Malakar, or rather Purnima Malakar, she's the daughter,
Champa Malakar is the daughter, my lord.
is the daughter. She was the result of a fling between Sanjit Malakar and Sippo Malakar. That's all that can be concluded, if at all. That is also subject matter of a suit.
My lord,
So,
my,
so to say that the marriage of Purnima Malakar is a second marriage is not at all acceptable. Now you make it.
I'll just submit my
Yes,
duty to
you can
submit.
close-
lord,
you can close your
kindly decide, my lord.
Yes,
On the date of marriage, on 01/10/1999,
yes,
Purnima Malakar was 14 years, 1 day old.
yes. So
So 14 years, 1 day, my lord,
And it-
that's a voidable.
punish Sanjit
That's a,
Malakar for child marriage,
that's a void marriage, my lord. That's
voidable.
voidable. There has to be a nullity declaration. There has to be an annulment, my lord, sorry.
So there's
So,
no
but nonetheless, it was 14 years. Now,
Yes.
my lord, I'll kindly submit, my lord. Is there a single, at least I have a registration certificate as per the special, I'll just come to the special marriage.
why
Act for
they are
now.
required to have it? She is a nominated wife accepted by the authorities.
My lord,
The employer himself says, she's my wife. Why she is required to
my
get it
lords,
declared?
my lords are.
All right,
Well,
noted.
just one submission, my lord.
Argument noted. Now 1 minute more, please.
One more.
That's it.
My lords are taking note of the nomination, what was made by the railways, but my lords are discarding a special
We have not
marriage.
discarded anything at all.
Special marriage certificate
It's
registered
just an expression of opinion.
and my
No
lord,
discarding as yet.
and the agreement also.
This council, please don't probe it. Conclude your arguments now.
And insofar as the jurisdiction is concerned, my lords,
Yes,
since an administrative authority would have the jurisdiction to decide,
yes, yes,
the tribunal would also have the same jurisdiction, because
Yes.
if the administrative authority decides, the tribunal has to decide the legality and validity, my lord.
yes.
And just the last submission, my lords. This is with regard to section 33 of the Evidence Act, my lord.
Yes.
My lords would come to the 125 application
Yes.
referred by the petitioner, my lords, which starts from page 108. I'll just quickly take your lordships to my lords,
Yes.
would directly come to page 110, my lords, of that
Yes.
judgment.
Yes.
Page 1110, paragraph 16. Paragraph 16, I'll read it out. PW1 Purnima Malakar deposed that she married Sanjit Malakar on so and so on in social form as per Hindu rites so and so, and after marriage she spent 1 year peaceful existence with her husband, and during so and so, so and so, so and so. PW1 deposed, my lord, lordship would skip that, lordship would directly come to the cross-examination. Next
Yes.
page, my lord, it's paragraph 8, put to cross-examination.
Yes.
PW1 stated that she does not know Shipu Malakar and she does not know with beforehand her marriage with the OP, and she was married to Shipu Malakar, but later on came to hear that Shipu is the married wife of Sanjit Malakar. Shipu is the married wife of Sanjit Malakar and has a daughter. PW1 stated that Sanjit had filed a case against her and her family, but it was compromised on condition that Sanjit will take her back along with the children. So and so PW1 denied the suggestion, so and so. So,
Yes.
my lord, the petitioner herself agrees in her cross-examination that I am the legally
She
married.
heard,
My lord,
not agreement,
came to hear that she
came to hear.
Yes, came to hear. The next paragraph, my lord. Please, paragraph 17. Paragraph 17.
Yes.
It's PW2 Narayan Chandra Malakar, who's the father-in-law.
Yes.
The deceased father, the lordship would come to father-in-law in petitioner deposed that she married his sons 13-14 years back in social form, and out of their wedlock they have a daughter and 2 sons. PW2 deposed that he started to live with another woman so and so, and that his son left his wife at
Yes.
her mother's house. In the cross-examination, lordship would mark that, mother. PW2 stated that the petitioner stays in the house. PW2 stated that before his Purnima, this without informing him, married a Muslim lady, Shipu Malakar. PW2 stated that he has not approved his son's relationship with the said lady Shipu Malakar.
So admission of another person is binding on that lady. You want us to believe that?
Yes, yes, that is because of section 33. I'll finish.
Oh, yes.
Section
Yes.
33 of the evidence.
Yes.
Yeah, no, evidence. Manual, manual.
Okay, very well.
I'll just. Yeah, no, that's what I- yeah, no.
Hmm.
Just-
Yes.
Section 33, my lord.
Yes.
Relevance of certain evidence for proving in subsequent proceedings the truth of facts stated.
Yes.
Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage, the same judicial or in a later stage of the same judicial proceeding, the truth of the facts which it states when the witness is dead. First, my lords, the husband has clearly stated in the WS and also in his deposition that I am the first wife and he married me first, and he's dead by the way. Well, he's dead now, my lord. Facts, if the witness is dead or cannot be found or is incapable of giving evidence or is
Yes.
kept away from adverse party or his presence cannot be obtained without any amount of delay or expense, under which circumstances of the case the court considers unreasonable. So, my lord,
Is the proceeding before tribunal a judicial proceeding?
my lord.
Is the proceeding before the tribunal a judicial proceeding?
No, I'm not referring to the, I'm referring to the judicial proceeding of the
In which
120
proceeding should we read this statement now?
that 125. My humble,
Mr.
I may be
Counsel,
wrong.
you
125
are
is
trying to
judicial-
say
My lord, sorry.
that as per 33, the admission made by X in a judicial proceeding is to be read in a subsequent judicial proceeding,
Yeah.
which
This is a judicial proceeding, my lord.
before the tribunal.
Present tribunal or my lord's.
Are you sure? Are you sure? Is a tribunal a court?
Yes, my lord, it is
a
vested
court.
in the powers of the civil court also. my lord.
Okay, very well.
It has the power to summon, examine
Yes.
witnesses, my lord, section 23.
Yes,
administrative regulation.
okay,
22, my lord. So my lord,
yes.
I state, my lord, the husband who is dead now,
Okay, very well. Understood. Thank you.
I'm deeply obliged, my lord.
Yes,
My lord, in reply to, my lord, his argument, my lord, I will point out one thing, my lord. It is honor. One, I mean, keep. MR.
yes,
But it is a part of record. My lord, in the MR case, which I have filed under section 25, there is
yes,
an evidence made by, my lord, the restaurant number 11, that she was a Muslim lady.
that is admitted.
Admitted.
There's no
Now,
dispute.
Lordship, kindly have a, my lord, with reference to that, my lord, statement or evidence, I may be allowed, permit to, my lord, refer to section 2, explanation C.
Of Hindu Marriage Act.
Yes, my lord. C, Hindu Marriage Act.
Yes,
But the Hindu marriage is a codified law, my lord.
yes,
There cannot be any other marriage other than Hindu Marriage Act, my lord, in addition to Special Marriage Act.
yes,
My lord, section 2, explanation, my lord, C.
yes,
Any person who is convert or reconvert to the Hindu Buddhist transfer also, she cannot come under this particular act,
Special Marriage Act. Then. Yes,
Hindu Marriage Act. Therefore, my lord, if marriage took place in 1997, at
yes,
that point in time, she was a Muslim, my lord. There is no evidence, no out of evidence, my lord, not even any statement.
yes,
Either in, my lord, application filed before OA or, my lord, the, my lord, 125 proceeding, which was initiated on the basis of their application. This is
yes,
MR case number 50 of 2010. My lord, nowhere, my lord, is stated that she was converted. Therefore, unless and until she is converted or reconverted,
yes,
then there is a specific bar. You cannot come under Hindu Marriage Act. Therefore, even assuming that there was some marriage, my lord, my lord, to wide extent, my lord, if I say that, my lord, there was a marriage in 1997 on the basis of this agreement to marriage, then also the marriage is hit by section 2 explanation.
yes,
Therefore, it is not a marriage because there cannot be any marriage between Hindu and Muslim.
yes,
Therefore, my lord, they cannot claim to be a wife with effect from 1997 at best in terms of section 18 of the Special Marriage Act. Since the marriage was solemnized or registered under the Special Marriage Act, it may be married with effect from, my lord, 2010.
Mhm.
On the other hand, my lord, Lordship has rightly pointed out,
So, Mr.
my,
Counsel, assume that it is a marriage from 2010,
yes,
and then there is an application by the employee
my lord.
to change his nomination. What is wrong in that?
My lord, unless and until, my Lordship kindly see that they refer to certain provisions. Expression uses cancellation, notice of cancellation.
Yes,
Inclusion and conclusion, my lord, is a gulf of difference. Inclusion means whatever is already in existence, some
yes,
more thing may be added.
yes,
And cancellation means or replacement means whatever was in existence, that has to be replaced or cancelled.
okay. Very well.
Item number.
Argument heard, judgment reserved.
There was also an IA filed by Champa Molakar, my daughter.
Next case.
The prayer was for compassionate appointment.
You file a suitable application wherever you want to do. Yes. This is what? Union of India's appeal,
It's against the same order.
same order.
It's against the same order.
Yes. So what's your argument?
Lordship, may I please your lordship. Lordship, the argument is lordship, so far the
They're defending their order.
11/9/2015, their challenge.
Yes.
And subsequently, this has come from the inquiry report.
Yes.
These are our the main supreme submission before your lordship. Number one. Number two, lordship, the nomination they have to change. Cancellation. They have to cancel. They have to give the cancellation notification.
Notice.
Yes. And thereafter, they have to include the another person.
Right.
But in this case.
No cancellation
no
notice was given to the
cancellation.
wife.
Yes, lordship.
Yes.
And moreover, after inquiry, it is found that the respondent is not a legal wife.
Yes. Yes.
And that is, I do not argue further
During-
more because.
During
already it-
subsistence of the first marriage,
Yes,
there could not have been a second marriage.
lordship,
Yes.
lordship. And there is a Supreme Court judgment also, there 2000, already my learned friend already argued.
Yes.
That is, one is lordship 2015. 2015 8 SSC.
What is the judgment?
This is for the lordship. This second marriage during the existence of the first wife.
Yes.
During the existence of the first wife,
Yes.
second marriage, it is required to be permission from the department.
Okay.
This is the Supreme Court also says, but they have not done that
Mhm.
in this case.
Yes. Yes. That was a Muslim parties here.
Yes, lordship.
Yes. In this
That
case,
is para
the
eight- para
employee
eight-
was a Hindu. There was no question of second marriage.
Yes, lordship.
Yes.
And it is para 8 and 11 is very important.
Yes, yes. Okay. Very well. Okay.
It is it.
Yes.
And another judgment, lordship, 2002 SSC.
Mhm.
That is already my learned friend has argued before you lost it. That is 431. Why it is specifically stated that when it is held that when there are two claimants of a diseased employee for pensionary benefit, the government, whenever required, can hold an inquiry. The Supreme Court also says. So accordingly, department has hold an inquiry, and
Mhm.
after inquiry, it is found that the first wife is the legal parent.
Right. Okay.
That is paragraph 16, 17, 18, 19.
Pass it. Yes.
My respectful submission is, lordship, whatever what are passed by the learned tribunal would be set aside, lordship.
Yes. Very well.
Well, I'll hand over my judgment. If your lordship decides that I'm the illegitimate wife, even then, my lord, my daughter is entitled to the DCRG. It's as per the rules. Illegitimate daughter is also entitled. My lord.
She has to file a claim.
My lord, the rules provide, my lord, illegitimate.
She has to file a suitable claim.
So the impugn order says, my lord, she's entitled. The impugn order, the railway says she's entitled. So the next application may not be required.
The impugn order says about the daughter.
Yes, it does. I'll point it out, my lord.
Mr. Burkas,
My lord,
what do you say about the daughter's claim?
because my lord, since the question is sub judice, unless and until my lord,
Otherwise, daughter,
daughter, of course, my lord, lordship is
She would
right,
be entitled.
illegitimate children.
to that extent, she is not an illegitimate. There is nothing like an illegitimate child. Yes,
Even my lord, after 1976 amendment,
yes.
both the children, whether legitimate or they are entitled.
So we can affirm the order to that extent. The direction to pay her the benefits as per her entitlements.
Yes. Lordship. No, they are entitled.
Yes,
My lord, of course, my lord, since the question is sub judice, whether she is the daughter through my lord that wedlock between the my lord Sanjit Malakar and
that the inquiry report also says. Inquiry report says regarding the daughter, which you have not challenged.
my lord, of course, my lord, after coming to know about the my lord suit they filed, we also filed a suit along with
Mr.
the
Burkas,
My
the inquiry report of railways,
my lord,
that is not challenged by you.
that's the matter.
So the consequences will have to follow as per that report.
My
No
lord,
denying that.
of course, I'm tight, my lord.
Yes, thank you. That's a very fair stand. Thank you.
Bless you.
Yes.
My lord, so far as my lord, so far as the my lord are playing for appointment, that cannot be my lord, lordship cannot issue any direction for her.
We will not issue any direction. We'll just say that she'll be entitled to her designated share as
Yes.
per the rules, that's all.
So far as the
Yes.
appointment part is
The interim
concerned.
order
Lordship.
says, my lord, Sri Champa Malakar is the eligible to get share of settlement dues on production of a guardianship.
That was-
certificate.
That's it. That's it. Nothing beyond that. So she, whatever additional claim she wants, she has to do it as per law.
My lord.
Yes.
And my lord, in the IA, my lord, with regard to compassionate appointment.
No, that we have.
There's a 2020 judgment, my lord, by Honorable Justice Chandrachud, which says illegitimate daughter is also entitled.
Go and file to the authorities. We'll leave you at liberty.
We have.
Because
my
they are
lord,
not considering, we already made an application.
So if you want an easy way out, we can decide both the appeal
my
saying
lord,
that your application may be considered.
my lord,
as
I
per
am
law.
having three, my lord.
That I'll be very
Okay.
grateful, my lord.
So of course, there will be a equal consideration.
My lord, I am having three, my lord, eligible children.
That's
my
not
lord.
an issue. Yes.
So we have equal right to, my lord. get
Yes,
some
yes.
consideration.
I'll be
True,
grateful,
true.
my lord, if that.
No. Then she too has children. They'll be entitled.
Three children.
Yes.
They'll take that, they would decide, the authorities will
Therefore, my
decide.
legitimate child will
So why
obviously
should,
not-
why should we enter?
That's what.
You approach the authorities.
Yes.
They will decide it as per law.
They should just consider, my lord, as per law.
And my lord,
An obligation.
our claim may also be directed to be considered. my lord.
Yes, let them consider. take it into
We are having three
So
eligible.
do you want an agreed order on this aspect regarding giving up the claim of Sipo Malakar and restricting it to the extent of the daughter? Do you want that order? No,
My lord, with regard to the pension, my lord.
Pension, my
The
lord.
pension, if your lord.
Whatever
decides,
the-
my lord, my lord,
whatever
that
the
I'm not-
benefits can accrue to the daughter under the rules.
Yes. So far as our share is concerned,
Under
Yes.
the,
we have nothing to say, my lord. So far as the consideration for compassionate.
All right,
I have-
we'll decide the matter on merits.
my lord.
Let it go. Yes,
Oblast,
Okay.
Very grateful, my lord.
yes. Next.
oblast, your honor.
Item number 20, passed over matter.
May I please, your lordship.
Disciplinary inquiry matters.
My lord, this is the appeal, like, challenging the, my lord, judgment of the learned civil judge, my lord. And the allegation was that, my lord, this is a misappropriation of fund, my lord.
Yes.
And the appellant was a bank employee, my lord. And my lord, impugned judgment
Yes.
is page 163, my lord. My lord, may I read the factual part from the judgment, my lord?
Yes.
Page 167, my lord. 167, my lord, para 6, my lord.
Yes.
Mr. So-and-so, learned counsel for the petitioner submits that on 21/2/11, while the petitioner was performing her duties as office assistant in the token counter to issue token to the customer of the bank. And in the
Yes.
process, one customer of the branch, namely Sri Sudesh Kumar Gupta, having saving accounts number so-and-so, came to the branch for opening a reinvestment plan account for rupees 1 lakh, and the said amount was deposited in his saving account. Thereafter, the said customer handed over the entire necessary document to his representative, Sri MD Fakhruddin, to withdraw the amount from the saving account as he had to attend his mother illness at Bihar. Accordingly, the said Sri MD Fakhruddin withdrew the amount from the case counter after producing token number so-and-so. On the request of the said so-and-so, a deposit pay in slip was written by the petitioner and handed over to Mohammed Fakhruddin for depositing the LS amount in the RIP account. However, due to want of signature of the said Sudesh Kumar Gupta in the RIP account form, the RIP account could not be opened and the account was left with Mohammed Fakhruddin. He further submits that though the petitioner had written the deposit slip, the petitioner could not have taken the LS amount in as much as the petitioner was in the token counter and not in the case counter. Learned counsel for the petitioner submits that on 17/3/11, the said customer came to the bank for getting a loan of rupees 90,000 only against the RIP counter folio dated 21/2/11,
However, as he was unable to get the RIP certificate upon which the customer was informed that his representative could not deposit the said money for once of signature of the customer. Therefore, on 18/3/11, the customer along with Mohammed Fakhruddin came to the branch with the request to the petitioner in helping them to deposit the amount of rupees 1 lakh in cash counter. Accordingly, my lord, the petitioner had handed over the amount to the cashier after producing the RIP deposit slip, and subsequently the RIP certificate was issued to the customer. It is further stated by a letter dated 26/4/11, the customer had intimated the branch manager of AZV Morigaon that the amount has been handed over to the petitioner for deposit in the cash counter. The customer had further intimated that the said amount was received back from Mohammed Fakhruddin. Further, the representative, namely Mohammed Fakhruddin, by letter dated 26/4/11, intimated the branch manager AZVV Morigaon that the said amount was in his possession since 21/2/11, as he could not deposit the same on 21/2/11. In as much as the customer did not provide his signature in the concerned bank documents, learned counsel therefore submits that the letter dated 26/4/11 would clearly indicate that no amount as alleged by the respondent has been misappropriated by the petitioner for a period of 21/2/11
1
to
month and 4
17/2/11.
days. That is grave enough, yes.
So, my lord, subsequently, my lord, departmental proceeding has been drawn up, and the petitioner has been, my lord, terminated from service
Yes.
on the ground that this is a question of trust. She has lost the trust. Accordingly, my lord, we file the writ petition, my lord. In the writ court also, my lord, only on the ground of, my lord, losing of trust, my lord, that the petition has been dismissed, my lord. However, my lord, this is not proved in the inquiry that whether the petitioner has, appellant has misappropriated the said amount.
Question of facts are now, there are 3 findings against you.
My lord,
3 findings of fact, finding of fact by 3 forums,
my lord.
disciplinary authority, appellate authority, and the red court.
My lord,
What is the scope for interference?
My lord, appellate authority, my lord, in the appellate authority, my lord, even that order about the appellate authority, my lord, there is no reason order has been passed against my appeal, my lord, my appeal, my lord.
The red court has assigned reasons.
My lord, only thing is that on the ground of, my lord, loss of trust, my lord.
Yes.
Now, my lord, my lord,
Temporary retention is an offense under section 406
my lord,
and 409. There are umpteen number of Supreme Court judgments.
my lord.
If FIR was filed, your client could have been convicted.
Well-
It's an admitted case that there was a retention for a period of 1 month, 4 days.
No, my lord, but however, my lord, this, my lord, retention, my lord, regarding this retention, my allegation of retention, my lord, this is not proof, my lord, because, my lord, in the Lada trial court, my lord, single judge, my lord, only, my lord, dismissed on the ground of, my lord, loss of trust. Now, my lord, my humble submission is, my lord, the question of trust will, my lord, come after, my lord, proving the allegation, my lord,
Okay.
and the charges. My lord, charges is only one charges is there, my lord, this is regarding, my lord, misappropriation of fund.
Yes.
Now, my lord, my lordship may kindly see the charge sheet, my lord. Lordship may permit, my
Yes.
lord. My lord, page 47.
Yes.
This is a charge sheet, my lord.
Mm.
Article of charge, my lord. May I read, my lord?
Mm.
Column 1, on 21/2/11, one of the customer of your branch, namely Sudesh Kumar Gupta, came to the branch for opening so-and-so account number of rupees 1 lakh, but inadvertently the same amount was deposited in the saving account. When the mistake came to your notice, you advised Sri Gupta to withdraw the amount from his SB account so that he could able to open the RIP account. Accordingly, Sri Gupta wrote a withdrawal for rupees 1 lakh and handed over the same to you along with deposit pay in slip mean for opening RIP account. On receipt of the withdrawal form and the deposit pay in slip, you issue the party's portion of the deposit pay in slips to Sri Gupta with your initial as token of the receipt of money, but no stamp was affixed on the counterfolio. Thereafter, Sri Gupta left the branch as it would take time for preparation of RIP certificate. In the meantime, you deposited the withdrawal form in the account as operator using so-and-so, and Sri Krishna Kanta Das, assistant manager, passed the withdrawal form payment as supervisor using ID number so-and-so. But passing officer and the cashier of the branch did not know the fact that the withdrawal amount would remain with the branch for opening RIP in the name of Sri Gupta. You also issued token number so-and-so against the withdrawal. It is reported that as per your instructions, Sri Fuhesor Soikia, who was in charge of the case, paid the withdrawal amount to Fakhruddin
and in turn Fakhruddin handed over the money to you, does you misappropriate the bank money of so and so instead of opening the rebank? My lord, here the allegation is that I have withdrawn. My lord, Lordship may kindly see the witness, my lord, management witness, where is my lord, it is clearly stated that that amount has been withdrawn by the customer himself. And he handed over to his representative, my lord, to Fakhruddin, my lord. And Fakhruddin could not deposit the said amount on that day because the signature is required. Subsequently, on return after 1 year, 1 month, my lord, that amount has been returned back by his representative, and my lord, the same has been deposited, my lord, with the help of the appellant, my lord.
Yes.
This is very much clear from the management witness.
Yes.
Lordship may kindly look, my lord, see management page 105, my lord. 105. Sorry, my lord. Sorry, my lord. Page 82, my lord.
Yes.
Please.
Are we supposed to reappreciate evidence at this stage, sir?
No, my lord. But only
Then
thing is that, my lord,
why
this is a
should we?
question of removal, my lord. This is a question of
Yes,
termination.
maybe.
My lord,
Give us one judgment wherein the appellate court writ at the stage of writ appeal. We are supposed to reappreciate the evidence.
but this is true, my lord. This is not there, my lord. But only thing is that, my lord, this is, my lord, here I have a judgment where the Supreme Court has said that regarding the question of removal from service, my lord, it has to
Yes.
look into the, my lord, natural justice has to be provided to the appellant, my lord.
Yes, what natural justice is not
My
been
lord,
done.
here, my lord, two evidence, my lord.
Yes,
Regard that the customer and his representative. My lord, I have submitted an application before the inquiry officer to consider the evidence of the customer.
yes,
That was not considered, my lord. And my lord, these two customers, my lord, the customer and his representative, my lord, has submitted a letter to the branch manager, my lord, regarding this incident that I have no, my lord, role to play in
he
this,
turned hostile.
my lord.
He turned hostile later on.
Well, that may be, my lord, but the question is, my
Yes.
lord, regarding the management witness, my lord. They have, my lord, deposed their witness, my lord, saying that yes, on the day of, my lord, withdrawal of the money, my lord, the customer was present in the bank. As well as, my lord, on the day of submission, my lord, they were redepositing the money after 1 month, my lord, that customer was present, my lord. Lordship may kindly see this witness, my lord.
Yes.
Just I want to satisfy your lordship, my lord. Lordship, my lord, page 72, my
Page
lord.
70, yes, read.
My lord, page 72 is the, my lord, management witness number 1, my lord. Lordship may kindly her evidence, my lord. Lordship may kindly page 75.
Yes,
On 21/2/11, my lord, in the middle. My lord, on 21/2/11, are you in the case counter and the withdrawal ME5 is paid to whom? My lord, MW1 replies that call the account holder, and then one Mohammed Fakhruddin came and received the payment.
yes.
So, my lord, the allegation that I
The
have received.
allegation is Mohammed Fakhruddin is your agent.
No, my lord.
Yes, that
It
is the allegation.
No, my lord. This is the, my lord, agent of the customer. And Lordship may kindly see, my lord. They have re-examined this witness. Kindly see, my lord. So, my lord, Mohammed Fakhruddin came and received the amount, my lord, from the case counter. And my lord, I was not working as a case, my lord, in the case counter on that day, my lord. I'm on the, my lord, token counter, my lord, on that day. And Lordship may kindly see. Next question, my lord. What is the denomination of the withdrawal? My lord, cannot remember the denomination. Why you made the payment to Fakhruddin? Lordship may kindly see. Sudesh Kumar said to hand over the payment to Mohammed Fakhruddin, my lord.
Yes,
This is the, my lord, direct answer of the management witness, my lord. So as per the, my lord, direction of the customer, my lord, the cashier paid that amount, my lord, to the Fakhruddin, my lord, not to me. So, my lord, now they want to establish this question that I have indirected, my lord. Lordship may kindly see page 676.
yes,
In the last part, my lord, cross-examination is over. PO is asked whether the re-examine the MW1. PO wants to re-examine the MW1, my lord.
yes.
So the question is, do you ask anybody of branch people for handed over the amount of withdrawal to Mohammed Fakhruddin, and whether you have seen the amount of withdrawal is handed over to anyone by Mohammed Fakhruddin, my lord? My lord, before this reading the answer, my lord, just my humble submission is, my lord, in a
Yes.
bank, when a particular customer went to, my lord, to the bank for withdrawal of my money, whether the cashier, my lord, or the person who is in the case counter, my lord, before handed over the money, whether he asked the, my lord, branch manager or any other, my lord, his colleague to my lord, take permission for, my lord, giving that amount, my lord? So here the answer is, my lord, lordship may kindly see,
Why did you prepare the deposit slip on 18th March?
my lord, 18 March, my lord, when the customer came, my lord. So that amount, his representative came and, my lord, deposited money, my lord. Then he asked me to help, my lord. Accordingly, my lord, since he is, my lord, our value customer, my lord.
Why should you fill the slip, sir? He is not an illiterate person. That establishes the charge.
No, that is, I have admitted, my lord, because my lord, customer, my lord, asked me for help, my lord. So I have deposited amount from the inside the deck, my lord, decks, my lord. Lordship may kindly see this answer.
Yes.
I asked Srimati Swapna before handed over the amount, my lord. What is the need of asking to the appellant, my lord, before handing over the money by the cashier?
Okay. Yes.
So I asked Srimati Swapna Kulta before handed over the amount of withdrawal to Mohammed Fakhruddin. And I have seen the amount was handed over to Srimati Swapna Kulta by Fakhruddin. My lord, this is came after the re-examination, my lord. And as per the banking law, it is not necessary to ask anybody, my lord, before handing over the money, my lord, by the cashier, my lord.
Yes.
And Lordship may kindly see that they wants to say that they wants to establish the on that day, my lord, on 18/3/11, the customer is not available in the bank. Whereas, my lord, kindly see this management witness, my lord, management witness number 2, my lord.
Yes.
My lord, page 85.
Yes.
You are relying on which witnesses' statements? MW1.
My lord, MW1 and MW3, my lord, on relying on their evidence, my lord, this, my lord, punishment has been given to me.
For your benefit.
My lord, for my benefit, MW3 and MW1, my lord.
MW1.
Yes. MW1 say, my lord, on that day, my lord, Sudesh Kumar Gupta was present on Lordship may kindly see whether Sudesh Kumar Gupta came to the branch or not on 21/2/11, my lord. Yes, he came to the bank on
There is no
21/2/11.
dispute. That is a charge. He came, gave that withdrawal slip. You did not open the account, retained you gave it to Fakhruddin for some other purpose. Then 18th March, the customer again came, he asked for his RIP account.
My lord.
Then you deposited the amount.
No,
That is what the charge is.
my lord,
Yes.
already MW3 has established that as per the direction of the Sudesh Kumar Gupta, the money has been given to the Fakhruddin, my lord, by the case counter, not to
Yes.
me. Lordship may kindly see again, my lord.
So, but you are relying on MW1 statement.
MW1 and MW3.
MW. Now come to page 74 and see the statement of MW1. Second question, you.
What is this, my lord? This is the question.
Signed by
Sign, see the answer.
Swapna Kalita.
MW1.
Yes.
The same MW1 you are relying on
My lord.
Yes.
is clearly implicated you.
You are on the, not on the cash counter. Why are you required to
No,
sign
no,
the?
my lord. This is on 18/3/11. Yes,
Yes.
on 18/3/11, my lord, I helped the customer, my lord. This is on.
No, you signed as the customer.
Yes, no.
Filling up a form is one thing. Signing as the customer is another thing.
Deposited by Swapna Kalita in the name of Sudesh Kumar Gupta. Why you were required to do that?
Your Honor, kindly see. My clear statement in my petition is that, yes, on that day, on 18/3/11, I have deposited.
Why?
Since-
Why you were
since I was
supposed to?
insisted by the customer, because it is not the case. My lord,
Why
it is-
were you required to fill in the deposit slip
My lord, the
in your
customer-
name?
No, not my name, my lord.
Oh, in his name, signed by.
Yes, my lord,
Signed
what
by you.
happened, my lord?
Signed by you. Why?
This is a deposit slip, my lord, for
Why
depositing the
is it?
money.
Why is the bank official supposed to sign it?
You can fill up a deposit slip.
But why sign?
Why sign it? And that too as the customer.
Deposited by Swapna Kalita in the name of Sudesh Kumar Gupta.
Lordship, may kindly see the next question, my lord.
Yes.
MW1 answer. This is the letter of Sri Dilip Kumar Bhuya, CC of SEB Moringao. Branch is on the case counter on 18/11. He said on his letter that he received rupees 1 lakh by Srimati Swapna Kolita on the case counter in the name of Sudesh Kumar Gupta.
Yes. Why is the employee required to deposit the amount of customer in own name? That is where the charge is. That when the hue and cry was raised, you came forward, please deposit the money.
My lord, on that day, what happened? On 21, it is a very, my lord, this is very clear. Clear that on 21/11, my lord, the money was received by the representative, my lord, as per direction of the customer. And I have
Okay.
already clearly stated in my writ petition, my lord, on 18/3/11, when the customer came in, my lord, asked for the money, REIT account, my lord, on that account only they came to know that that money could not be deposited on 21/2. So his representative came back and said that that money is with him. And branch, the account, my lord, the customer, again, my lord, request me to deposit that amount to help in opening the REIT account. Accordingly, I have helped.
Yes.
That is my lord, clear, my lord, some admission in the writ petition, my lord, even in the before the my lord, department proceeding, my lord.
Okay.
But this thing is not, my lord, proof regarding the misappropriation of money by me. This is not proof, my lord, in the departmental proceeding. Only thing is that trust has been lost. But my lord, before the trust, question of misappropriation has to be proved, my lord. And already in the appellate authority, my lord, my lord, kindly see the order of the appellate authority, my lord.
Yes. Page.
Page page 156, my lord.
Hmm.
My lord, 156.
Hmm.
Your
Yes.
appeal was placed before 44 board of directors meeting held on so-and-so. The director, while perusing the board note, opined that new materials fact has been placed and there is no merit of consideration of appeal.
Yes.
So board director decided to dispose of the appeal by upholding the decision of the disciplinary authority as communicated so-and-so. Hence, your opposite appeal petition is hereby disposed of.
Yes.
Well, without citing any reason, man. So this is my ground in this appeal. At least, my lord, in the appellate authority has to pass this order, my lord, by citing my lord, the proper and just reason.
Yes.
And the learned, my lord, learned singles is also, my lord. Only thing on the one ground, my lord, the question of trust has been decided, and this is the, my lord, writ petition, man.
Yes.
Then my humble prayer is, my lord, before, my lord, deciding the issue on the trust, question of trust, the charges has to be, my lord, proved, my lord.
Yes.
Because the question of misconduct, my lord, the charges of misconduct is not proved by in the departmental proceeding, my lord.
Yes.
Maybe, my lord, in my lord, 18/3/11, my lord, maybe I have signed a deposit slip and deposit the money, but this is not proved in the departmental posting that how that money came to him and on that day how he deposited.
106 of the Evidence Act.
My lord.
Facts, especially in knowledge of a person. You can't put that question. You have to give the explanation. What is your explanation? How did the money come to you?
My lord, on that day, I have already stated, my lord,
Yes.
that when the person customer came and asked for the, my lord, apply for the loan, then
There is a
only-
cross-examination on this aspect from MW1.
Yes,
Where is the cross-examination?
this is not there, my lord. Only he
Where
sees,
is your explanation
but this is not
regarding?
there.
It's not there. Then 106 closes the things. That's all.
I rest it with that's it, my lord.
Yes.
My lord, may I read only 3 paragraphs of the judgment passed by the learned single judge?
Yes.
Only 3 paragraphs. My lord, Lordship may come to page 173 of the appeal memo.
Yes.
But this findings has been passed by the learned single judge by considering all the materials available on record,
Yes.
my lord. May I read, my lord? The proceedings of a departmental proceeding has been annexed to the writ petition as annexure 15. This court has considered the entire proceedings of the state departmental inquiry, the oral evidence of both the management as well as the defense, has also considered by this court. The consideration of the same would indicate that the signature of the petitioner in the cash deposit slip of the RIP for rupees 1 lakh has been identified. This has been done by MW1 as well as MW3. Further, at the end of the departmental inquiry, opportunity was given to both the management and to the petitioner to produce any further witness, evidence, documents to the inquiry. However, it is seen that both the management as well as the petitioner stated that they have been given equal opportunities in the inquiry and the presenting the case, and there has been no denial or any violation of natural justice. So therefore, any submission made by my learned colleague.
His argument was on appeal. Appellate authority has not assigned reasons.
My lord. But to that effect, my lord, my respectful submission is that it may not be in so many words, but what is that they have perused. Had they come to a different finding, that the finding passed by the DP is different, then they would have given some reasons, my lord. Since they have, after perusal of an entire record, they have confirmed with the judge of the punishment awarded, my lord. This is merely a communication of the decision of the, in my most respectful submission. May I read, my lord, the further proceeding?
Continue.
Accordingly, the proceedings were concluded and the signature of the inquiry officer, presenting officer and the petitioner and the DR were recorded in the proceeding. On conclusion of the inquiry officer submitted the inquiry report wherein it was established that the RIP deposit slip counterfoil dated so-and-so has been prepared and written by the petitioner and issued by the petitioner to Sudhir Gupta, customer, against withdrawal of ₹1 lakh. It was further established that the petitioner deposited ₹1 lakh on, petitioner is the appellant before your lordship, my lord.
Yes.
1 lakh on 18/3/2011 against the counterfoil of the said Sri Sudhir Kumar Gupta for RIP receipt dated so-and-so, and therefore the charge level against the petitioner was proved. On a consideration of the inquiry report, the disciplinary authority notified the petitioner with regard to the proposed assessments on so-and-so, and
Yes.
further opportunity was also given to make a written representation against the proposed punishment. Thereafter, the impugned order dated 24/12/2012 was issued by the chairman and the disciplinary authority imposing the punishment and removal from service, which shall not be a disqualification for future employment. Next paragraph, I'll read, my lord.
Yes.
Paragraph 15. On a consideration of the inquiry proceeding as well as the inquiry report, this court is of the considered opinion that the findings recorded by the inquiry officer cannot be said to be based on no evidence.
Yes.
Particularly when the signature of the petitioner was identified by MW1 and MW3. Therefore, I am of the view that the finding of the inquiry officer cannot be nullified in as much as there are relevant findings in support of the conclusions recorded by the inquiry officer. All relevant documents were produced in the inquiry to establish the charge level against the petitioner. At no point of time, the petitioner had raised any objection with regard to the authenticity of the documents that were produced by the bank management. My lord, a finding of fact by a constitutional court. After perusal of all these records, the lordship in exercise of appellate jurisdiction may not like to, my lord, take a different view.
Right.
In response to that, my lord, I am relying on a judgment passed by this honorable court. I have given the list of books, my lord.
Yeah.
This is 2004 1 GLT 117.
Yes.
Only one
2000.
paragraph I will read out, my lord.
Yes.
The scope of the writ appellate court, my lord, by division bench of this court, 2004 1 GLT.
Yes.
Lordship, I directly come to paragraph 26 for a moment, my lord. Only one paragraph I will read out. This is by division bench of this honorable court.
Yes. Yes. You said so thrice.
May I
Yes.
read, my lord? Paragraph 26, Lordship, at page 135.
Yes.
May I read? While dealing with the present appeal, one has to bear in mind that a writ appeal is really not a statutory appeal preferred against the judgment and order of an inferior court, to the superior court.
Yes.
The appeal inter se in a high court from one court to another is really an appeal from one coordinate bench to another coordinate bench. And it is for this reason that a writ cannot be issued by one bench of the High Court to another bench of the High Court, nor can even the Supreme Court issue writ to a High Court. Thus, unlike an appeal in general, a writ appeal is an appeal on the principle, and that is why, unlike an appeal in an ordinary sense, such as criminal appeal, where the whole evidence on record is examined by a new appellate court, what really examines in a writ appeal is the legality and validity of the judgment and order of the single judge, and it cannot be set aside. My lord, I'm reading it. my lord. And should not be set aside only when there is a patent error on the face of record, or the judgment against the is against the established or settled principle of law.
Yes.
Next part, my lord, is very relevant, my lord. If two views are possible and a view which is reasonable and logical has been adopted by a single judge, the other view, howsoever appealing such a view may be to the division bench, it is the view adopted by the single judge which should normally be allowed to prevail. Therefore, my lord, there is no second view, my lord. Even if lordship think that even if two views are possible, then the view which has been taken by the learned single judge by giving sufficient reasons may not be, my lord, interfered with.
Yes.
That is my respectful submission, my lord.
Okay.
My lord, in reply to regarding the order of the appellate authority, my lord. This is not that it is mayor relying the, my lord, the conviction or the order, my lord, of the disciplinary authority. It is not that fact, my lord. As per Supreme Court, my lord, I am relying on this judgment. Here, my lord,
Mr. Counsel,
my lord.
now the Red Court has already entered into the merits of the matter and has given its own satisfaction
My
after
lord, that is
perusing
true,
the
my lord, but
evidence.
regarding this
So the
aspect, my
argument
lord-
regarding appellate authority no longer survives.
My lord, this thing has not been considered.
Yes.
That's why, my lord, I am submitting, my lord. Here, my
This is
lord,
an enhancement of penalty. Their reasons were necessary.
my lord,
Yes.
my lord, can you see para 9, my lord, para 19,
Yes,
2008, 3 SSC 469.
yes,
My lord, this is also regarding misappropriation of fund, my lord.
yes.
Here, what happened, my lord, para 19, my lord, near it, my lord. Having considered the submissions made on behalf of the respective parties and also having regard to the details manner in which the under administrative tribunal dealt with the matter, including the explanation given regarding the disbursement of the money received by the respondent, we see no reason to differ with the view taken by the administrative tribunal and endorsed by the High Court. No doubt, the divisional forest officer dealt with the matter in detail, but it is also the duty of the appellate authority to give at least some reason for rejecting the appeal preferred by the respondent. A similar duty was cast on the revisional authority, being the highest authority in the Department of Forest in the state. Unfortunately, even the revisional authority has merely indicated that the decision of the divisional forest officer had been examined by the conservative of forest,
Yes.
wherein the charge of the misappropriation was clearly proved. How he too did not consider the defense case as made out by the respondent herein and simply endorsed the punishment of dismissal, though reducing it to removal from service.
Very well. Thank you.
Well,
That's all.
definitely.
Arguments heard, judgment is up. Rest of the list will take up at 2.
I'm deeply obliged.
Obliged.
Pray for passing over the matter for the Mr. Das is not turning up, my lord.
Mr. Das,
Mr. BC Das.
he is for the appellants.
He is for the appellant.
He is not available today.
No, he is available, my, he is sitting all along in the front of
All right.
here, my lord. Just a.
As
few
prayed,
minutes,
list up 2 weeks. Okay.
Matter maybe if we have some urgency, my lord, let the matter be fixed on next Tuesday, my lord.
Not possible, sir. Thank you.
He is coming, my lord. He is coming, my lord. Mr. Das is coming.
Lie, DJ. Yes.
I'm sorry, my lord.
No, it's okay, sir. Please.
But in this case, my lord, an issue which was earlier decided by a competent court between the same parties was sought to be reopened and reviewed in subsequent proceeding
Mhm.
with regard to the same parties. The issue here is, my lord, the petitioners, the writ appellant, they were two persons are there. They were appointed as junior engineer in the Arunachal Pradesh Civil Service.
Yes.
Subsequently, in 1992, they were appointed as junior engineer.
Yes, go ahead. He's there.
In 1996,
You are for all the three respondents?
Lordship. Lordship for the government. Lord.
Okay. Yes,
in 1992, they were appointed as junior engineer.
yes.
In 1996, they were officiated, they were given officiating promotion as assistant engineer.
Mm, yes,
And subsequently in 2003, they were regularized, but subsequently it was cancelled. Ultimately in 2013,
yes,
they were regularly promoted with effect from that date,
yes.
prospectively.
Pursuant to the recommendation of DPC.
DPC, recommendation of
Yes.
DPC. They challenged that order, saying that they are entitled to seniority from the date of their officiating appointment,
Hmm.
because they were continuously in the service,
Seniority in which cadre?
in the career of assistant engineer.
Without being promoted.
No, they were promoted subsequently.
So
They
without
regularized.
holding the post.
No, they
in a
were
subs-
officiating, they were.
Sir, the query is, without holding the post in a substantive capacity, whether an officer can claim seniority in the cadre.
But in terms of the direct recruit assistant engineer, in clause B of the principle B of
Yes,
that decision, they are entitled to if they continue for a long time,
yes.
then they are entitled to their seniority.
Very well.
Even then,
Continue.
the earlier decision that was there, that had decided that they are entitled to seniority
Hmm.
and referred the matter back to the DPC.
Yes,
The DPC now decided the matter, saying that they are not entitled. Again, that was challenged. This is the main issue here now.
yes,
And in that case, the earlier decision by the same judge that decided that the issue that the petitioners have been able to prove that they had proved their continuous service, and therefore principle B of the decision of the Supreme Court in directly to the assistant engineer
yes.
would be covered. They were entitled to that one. But in the subsequent proceeding, that decision was reopened and reviewed, saying that this did not attain finality.
Yes.
That is the matter. But I place your lordship to the
Yes.
first judgment, my lord, page 45, 62. Page 45.
Yes.
Your lordship can turn to paragraph 17. Seventeen, 20, and 25.
Yes.
Paragraph 17 at page 56. In
Yes.
regard to the second condition of the state, respondent, learned counsel for the petitioners refer to the dictionary meaning of the word
Yes.
uninterrupted. That decision was given herein. The Oxford Dictionary, so and so, in compact Oxford Dictionary, last three lines. Thus the words continuous, uninterrupted, without breaks are synonymous. Therefore, the argument of the State Council that the petitioners continued in the officiating post by virtue of the orders of the Honorable Court, and as such continuation in the post cannot be said to be uninterrupted, is illogical and not sustainable in law. The United States, then paragraph 18, the United States Council at no point of time disputed that the continuity of the service of the lead petitioner in their officiating capacity.
Yes.
But in the course of his argument, tried to impress upon the court that the petitioners continued in the official post only by virtue of the orders of the Honorable Court, and therefore his continuation in the post cannot be understood to be uninterrupted one.
Yes.
Then your lordship can turn to paragraph 20 at page 58. This is the finding, paragraph 20, 25. Considered the above libel submissions of both the parties and gone through the bunch of documents so filed by the petitioner herein and various judgments pronounced by the court, while the petitioners entered into several rounds of litigation to resist the orders of the respondent authorities who intended to revert back the petitioners to their original post. However, from the various orders, the interests of the petitioners were all protected in the sense that they were allowed to continue in the same officiating post of promotion. In view of the orders so passed, as well as the documents so relied upon by the petitioner, and the decisions to be rendered by this court, and the decisions so rendered by this court, it can be at best held that the petitioners are in continuous service in the same post as assistant engineer ad hoc officiating promotion. The respondent authorities by the order itself, so and so, made it clear that the effect of ad hoc promotion was given effect to from 1996, that is the date when they were officiating officially promoted, without any break, may be treated as a duty for all practical purposes. But that document will be available at page 72 of the original record of the writ petition number 340 of 340 of 2010. Then your lordship can turn to paragraph 25. Page 61.
Yes.
Paragraph 24. Paragraph 24 and 25. In the absence of such specific material, relevant material before this court, also about the last DPC, this court is not in a position to interfere into the order of the respondent authority, while the petitioners have been granted impugned order of regularization of the service of the petitioner. In the absence of findings of the DPC, this court is also not in a position to appreciate as to what is the parameter of the consideration which was placed before the committee, particularly in respect to the petitioners. But as because the services of the petitioners have been regularized with effect from 14 to 2013, it can be considered that the continuous service of the petitioners from the date of their officiating promotion as assistant engineer, that is 1996, was not considered. In the instant case, the petitioners have been able to prove that they are in continuous service since from the date of their appointment on 23/3/1992 and officiating promotion as on 19/3/96 without any break. So there is a scope on the part of the respondent authorities to appreciate such aspect. That apart, the criteria for eligibility criteria for qualifying period of promotion as per the recruitment rules is to be decided by the appointing authority having regard to the recruitment rules. If the case of the petitioners is found to be qualified for promotion in such continuous period of service, then also there is a scope for consideration for promotion of the petitioners from the due date after qualifying period of service, even though all such matter was not specifically pleaded by the respondent authorities by filing counter affidavit. But this code is bound to appreciate all aspects, not to defeat the ends of justice. In that view of the matter, paragraph 26 at page 62, in view of all other above, the matter was referred to matter is referred to the respondent authorities to appreciate all aspects by holding a proper DPC, by taking into account the seniority of the petitioners will be counted from the date of appointment and not from the date of regularization. And the officiating period is to be counted for considering seniority. Qualifying period for promotion shall be considered as per the recruitment rule. The respondent authority will prepare a seniority list, gradation list positively and place the same before the DPC for determining all aspects of controversy. It is also noted that the petitioners have already filed their representation immediately after the aforesaid order of application, they so and so, but the same are yet to be adjudicated by the respondent authorities. Both the writ petitions disposed of with the direction to the respondent authorities to reconsider the representation of the petitioners in view of the observations and findings as indicated above, with a reasonable period, preferably 4 months. After that, my lord, DPC said, and the DPC decided the matter. That will be available at page 69. '69, 70. '69, paragraph 3, I am reading from paragraph 3, my lord. And whereas
The judgment.
perusal of the speaking order dated so and so, passed by the then Commissioner Government of Arunachal Pradesh, which was affirmed by the Division Bench of the Honorable High Court in its judgment and order dated so and so, revealed that on so and so, when Tarok Gangu and P. Khime, the appellants herein, the petitioners were promoted on ad hoc basis as an engineer. They were junior to 467 junior engineers in the seniority list. It is clear from this fact that they were allowed to officiate as assistant engineer on ad hoc basis to the prejudice of 467 incumbents. This is one reason. The second reason, paragraph 4, and whether the committee is firmly of the view that their ad hoc appointment as assistant engineer was purely a stopgap arrangement, and this case is squarely covered by para 44A of the judgment and order of the Honorable Supreme Court of India and the direct recruit class 2 engineering association, so and so. My contention is that, but it is available at the principle at paragraph 44B will be applicable. They say that it is A will be applicable.
Can we have a look at the order dated 15/2/2016 passed in WPC 1382?
13/2,
Where is that
2016.
judgment, please?
Yes, madam. 13/2, 2016.
15/2/16. WPC 1382.
That is that page, my lord, 76, 89, 15/2/86. No. WBC 1382. That was disposed of
Sir,
On-
where is the order?
of 1382, my lord.
Yes.
1382 order is that this is not available this is available in the record, my lord. In the WPC number 340 of 14. This arises out of 340.
So we would like to see that judgment, sir.
Yes.
But this doesn't carry the date, but this is the final disposal of 1382
Let us see.
of
This is
2006.
noted in para 20 of the impugned judgment.
Yes, yes.
Yes, man.
Let's see the order, please.
340.
Actually, my lord,
Huh?
three petitions were disposed of by the order, my lord.
Yes.
It is available at page, oh, my lord, in this brief also it is available. At page
Yes.
141,
Yes.
141.
Yes, please. Is there? This is not the order, sir.
Yes, this is done.
This is the order. This is 22/5/2009. We are asking for 15/2/16.
13 to 16. Oh, yes, yes. No, original. 13 to 16,
15/2/16.
15 to 16. Yes, sir.
15/6, probably this should be.
15 to,
It should be 15/6. The date.
it's 15 to 6 actually. Page 76, 89.
ये कुछ date गलत आ रहा है.
Wrong reference.
Yes. Yes, this is the order. Yes, sir. Yes.
76, no, oh,
But not at 141.
oh, the page 2.
Not this one.
This is the same one probably. 1382 is the date.
1382.
Yes.
There is 22/5.
Yes, yes, please carry on.
What is that page 141?
Yes.
Writing is. Writing is.
Writing is good. No, in face of these obligations, whether in the first term, then it's entitled.
Not correct,
No.
but then that was required to be corrected by the state. by
Yes,
filing the-
maybe, but in DPC, they've done it. Any rates, they are below 60 something. And about. And they give them the same.
They want to be there, but only technical point whether
No, it's still observation basically.
Uh,
That is in,
that is not an obligation, that's a finding.
maybe, that finding is contractual.
That is
Adjournment
contrary.
order in the very same case, same set of service, same service,
We can.
same income.
We
We will correct it. Yes, the learned synergy data has already, right? Make amends. Yes, please.
Paragraph 18, where the finding,
Yes,
page 149.
yes, sir.
The aforesaid facts, though not altogether irrelevant, cannot override the determination that has already been made to the effect that the petitioners, by virtue of the seniority in the career of junior engineer, were not entitled to the promotion,
Officiating
either on officiating
by virtue of interim orders passed by this.
or on regular basis
Yes,
to the next higher grade post of assistant engineer. The petitioners are presently continuing in the post of assistant engineer under the orders of the court. As the petitioners have continued for long, they must have come up to higher levels of seniority while affirming the order dated 15/2/2006 insofar as the petitioners number 1382 as a concern, were the view that their continuous in the post of assistant engineer
page number.
on
20.
officiating basis is a matter that should be left to be determined by the authorities of the state.
Read para 21 of the penal. There the learned right to.
In 2003, they were,
Yes,
in 2003,
yes, sir.
they were regularized. And in 2006, that regularization was cancelled.
Yes,
Against that cancellation, this writ petition was filed.
yes,
And therein, it was observed, while dismissing the writ petition,
yes, please.
as the petitioners are continuing on official basis at page 150,
Yes,
were of the view that their continuance to the post of assistant engineer on officiating basis is a matter that should be left to be determined by the authorities of the state. the authorities of the state in doing so will take into account the fact that whether if the petitioners are to be allowed to continue on officiating basis and if prejudice will be caused to their seniors. If such prejudice is caused to any senior, naturally such officiating arrangement will not be allowed. However, in the event so much prejudice results, no such prejudice results, the authorities will be at liberty to allow the petitioner to continue in the post of assistant engineer on officiating basis.
Even assuming that they were continuing the job. Whenever DPs is there, they are required that in accordance with their. That is not, that metal is not there. Yes, please.
Thereafter, they were allowed to continue in their officiating basis by the government. And
Yes.
subsequently in 2013, that is at page 43,
Yes.
by the recommendation of the GPC, the 39 junior engineers were regularly promoted, and thereafter, in that list, the petitioner's name was also there. Therefore, it can be said that their officiating promotion was regularized with effect from that date. That is the
Do the
condition.
recommendations read so? Do
Yes.
the recommendations mention this fact, what you are proposing or projecting? That this,
Page
their
43.
their officiating promotion was regularized? Read, please.
Page
Yes.
43. No, because it was not given, and that's why the writ petition was filed.
Yes, sir.
Page 43.
Yes.
Was pleased to order for promotion, the following junior engineers to the student with effect from the date of recommendation. And serial number 32 and 36 are the two writ appellants,
Yes.
32 and 36.
Very well.
Then we claimed that our officiating seniority should also be given.
Without
therefore-
impleading any of the persons likely to be affected as a party respondent,
But however, my lord, that writ
even in
petition
the
was
representative capacity,
decided. My lord,
even in the representative capacity, no one was impleaded.
that was not required in that sense.
That is your
Because-
argument, sir.
There is a judgment in that judgment. There is a judgment saying that issue was decided that whether we will get it or not.
Very well.
And that judgment says in paragraph 25.
That you read, sir. That you read.
That
Yes.
that was thought to be reopened and
That
reviewed.
judgment rather is per incuriam in view of the order passed in your writ petition in 2006 by a division bench. Does the judgment take into account that division bench order? The findings in the judgment which you rely upon by the single bench
Yes.
are contrary to the observations made by division bench in 2006.
It was ordered to be clear. Till 40, I'm just 45.
That is judicial indiscipline rather.
Yes,
Yes.
45.
The division bench judgment probably was not brought to the notice of the court. It was
No,
not,
it was brought.
not.
It was brought, that is at page, my lord, paragraph 60.
1/6.
No, sorry, page 60,
Yes.
page 60. Before that page, my lord, page
Yes.
59, paragraph
Yes.
22.
Yes.
There is a reference to it.
So once the court says that this is the domain of the state authorities, why the red court is to direct that the seniority will be counted from the ad hoc appointment? The division bench says that this is the domain of the state authorities. Yes.
No, from the date of, because of the principle in 44, paragraph 44B
That,
of the
that of
direct
course,
people exchange.
that we'll consider, sir.
That,
Yes,
that because of that one, the honorable court directed, Lord Single Judge directed the DPC to consider the same and to take into account
yes.
their ad hoc appointment because they have continued for a long period of about 17 years.
Under interim orders of this court.
Yes, but
Yes,
they have continued uninterrupted. The government did not take any action against
yes,
those orders. Even when the court said in 1332
yes.
that the state government will be at liberty to whether their continual sufficiency will be continued or not.
Yes, please.
If it causes prejudice to the other persons concerned, then they may not be given. But the government gave it. And we continued uninterruptedly. That is the question.
Sir,
For
the
17
problem
years.
is when the learned single judge quoted para 18
Yes,
in this judgment,
yes.
the first 4 lines which are material, they were omitted. Please read.
The petitioners are presently continuing.
Sir, please read para 18 of the division bench order in entirety.
Yes, yes.
Those 4 relevant lines, they were ignored.
141.
One 149, page number 149.
149, yes.
It's really strange. The learned single judge starts by omitting those lines.
Right is right.
What is the reason for omission? Can this particular para of the judgment is put? Why the beginning lines are omitted? Which are most material? Yes. Please read, sir.
Yes,
And
yes.
let us know what is the meaning of these lines.
Yes. The aforesaid facts, though not altogether irrelevant, cannot override the
Determination.
that has already been made to the effect that the petitioners, by virtue of the seniority in the career of junior engineer, were not entitled to promotion either on officiating or on regular basis to the next higher post of assistant engineer.
So this is determined by the division bench. Finding to the contrary by single bench, what would be the worth of such a finding be?
The petitioners are presently continuing in the post of assistant engineer from the orders of the court. Because when they were, at that point of time, there were no rules as such. But the rules came in 2006. In 1966, they were given ad hoc promotion.
That ad hoc promotion, the division bench says, it determines that period can't be counted towards seniority. So that is the end of the things. You have to say anything more, please?
No, I was on the point only that once it is decided whether.
Sir, that decision is contrary to the observations of division bench. And very interestingly, please read that the learned single judge, same single judge has decided both petitions. Probably in the second round, it was an attempt to make amends.
Yes.
Because the first 4 lines of para 18, which were most material, were omitted in the first round of decision.
But it was in any case, it was a review of the judgment.
Whatever, if the judgment.
But the review is not permissible in that.
Very well, we will deal with that. Don't worry, sir. We'll deal with it. It was something done in defiance of a division bench order. Why should it be considered at all? It's per incurium on the face of it. Is it not? You won't admit, of course. You are online. Your clients might be listening to you.
But only point was, my lord,
We have understood what you are trying to say, sir. That the subsequent round of litigation was not a review of the earlier observations.
Yes, yes.
Understood.
Yes.
But our observation is that the first round of litigation, there is an express omission of the relevant lines from the division bench order, which goes against your clients. Thank you. We can hear the other side. Yes.
Well, your lordship has already seen the should I say error, my lord, in this case.
It's
Time
very
and again, they have been
interesting.
trying, my lord, this is not the only case appeal, my lord. They have come umpteen times, my lord,
Yes.
from 2000. Every time they will somehow obtain a stay order, my lord. And they will.
Why didn't you challenge that?
Somehow what?
Why didn't you challenge that order?
My lord.
That earlier round,
Yeah.
why didn't you challenge it?
But we had also filed appeal, my lord. That was dismissed, my lord, ultimately. My lord, yes, we had filed the status, also filed appeal against the order, but our speaking order is clear, my lord. The
Yes,
speaking-
we have read that.
Yes, my lord, our speaking order is clear, my lord.
Yes.
And my lord, that, my lord, they seeking seniority, my lord, but they haven't made all those to be affected party respondents, man.
And as many as 467.
Yes, my lord.
Yes. Okay. Very well. All right. We'll dictate the order in chambers.
Much obliged.
You can run this too. वापस दे दीजिए. We'll have to adopt it in the manner seems to have escaped notice.
Oh. Much
Yes.
obliged.
Yes, dispose.
वो भी नहीं बोलते. Just put it there.
Really strange.
It's construed the direction.
Yes, true, true. 22.
Well,
I think, yeah, we have done enough hearings today. Hmm. क्या कहते? So I think we have done enough hearings for the day, sir. We'll have your matters some other day.
Your lordship's permission.
Yes.
Item number 32 to 32 to 42, these are reservation in promotion matters
Yes.
where there is an urgency because of an OM. After the judgment was passed, the government completely brazenly brought in the same clauses which were struck down,
Mhm.
resulting now what has happened, all our seniority, my client's seniority has been, we have been downgraded. And there's a multiplicity of proceeding.
Litigation.
In fact, your lordship, considering my submission had brought it before the single bench, division bench, especially item number 35, where the constitutional validity of the OM has been challenged. Well, if your lordship is giving some time, at least I pray that at least the effect of the order may not, because they have overruled the binding decision.
Without applying mind,
Yes.
no stay without.
This matter may be fixed upon.
The council, the orders pass without
Yes,
application of
no,
mind.
I'm not.
You have seen the
definitely.
consequences.
Yes, yes.
So-
Well, can it be on Tuesday next? Because my urgency is that since your lordship is taking up all the matters.
Tuesday, you are asking for 4th April.
Only the.
You yourself,
Malad,
you
if not
yourself
the other, that.
pose a question to yourself.
Malad?
Pose a question to yourself.
Yes.
4th April,
Oh, yes.
what do you want us to do?
I just missed that part.
We'll request that the Platinum Jubilee celebrations
Yes, yes.
should be deferred
After
for the next year.
Let it be after 18, lordship.
These matters will take time.
Obviously, obviously.
It will take.
We have heard since the morning, we have heard, I think 4 to 5 matters finally.
So let it be after 18th of
Yes.
April. It's okay.
Maybe
25th, 26th, and sign it.
27th, 28th, 28th April.
Of April.
April, lordship.
Yes,
28th of April.
Is the third. Is it Friday?
right.
Can, lordship can. because
No,
of my
Thursday.
urgency-
We'll have it on 27th.
27th.
Yes.
Better.
Lordship, 27th.
My lord, my item may be kind of listed on 24th April, 24 or 25th.
24th is a holiday, sir. It's a holiday. We have a big calendar for your benefit now.
That's after vacation, lordship. After vacation.
25th.
Put it in May.
My lord, lordship,
9th May.
your matter, lordship, I taken
Yes.
maybe on 26th. We have given maybe on 26th, lordship, they have a problem.
26th.
Yes, 26th. If it is.
26th you want.
Lordship.
26th is Wednesday,
Yes, lordship.
not on a Wednesday. We have to fix a hearing day.
27, there is
20
little difficulty. Can it be on 25th, lordship, Tuesday? PDP is also.
You may have it on 25th.
So far, item number 28 is concerned, my lord. There is another item, say this is 8 of 20. Both may come together, my lord.
Which one?
Item 28.
38.
28.
You want some other matter to be connected?
My lord, that already come, my lord, but today it has not come. 8 of 20.
Registry is directed to tag the file of excise appeal number 8/20
Right.
with this appeal unless both the matters for hearing after 4 weeks.
May I please your lordship?
We have got a joint prayer, my lord.
Yes.
Making a joint prayer, my lord, so far as item 25 and 26 are concerned, my lord.
Yes, please.
My lord, may I, my lord, may I pay for my lord for listing this matter after 4 weeks, my lord?
Yes.
We are making a joint prayer, my lord.
4 weeks.
After 4 weeks, my lord.
4 weeks.
29:30.
29/30.
29.
Okay, 29/30 after 4 weeks.
All right.
As per it.
I am so obliged, my lord.
That's it. May.